I beg to my lord mention a matter, my lord. This matter is disposed of matter, my lord. But, my lord, we are the interested parties, my lord. We are not heard, my lord. For that reason, I have made 3 applications, my lord.
Please give. We'll include it.
Yes, my lord. Grateful.
Your Lordship, may I permit you to mention for inclusion on application?
Yes. Yes.
I'm
Yes,
praying for leave because this is a opposition political party. Today is the foundation day, my lord. The last year also, my lord, the state give a embargo, and after all, my lord, I get the permission from the court. And last year also, my lord, will remember, my lord, who is fallen from the my lord. They last year, my lord, they allotted in Indore, my lord. This year, we get permission from the military authority to hold the meeting in Shahid Minar, my lord. But giving the instances of 2023, one political clash, there is an embargo in this order, my lord. The highest political leader of this political party, my lord, they will not present physically, my lord. Kindly, my lord, take up this matter because from 12 noon, my lord, the meeting.
It's running in the list today.
No, my lord. I'm praying for yesterday order is passed, my lord. Yesterday,
Today
otherwise, my lord, this matter become infectious, my lord. It's the only political party in the state, my lord, who have the one single MLA, my lord, and both the other two political, one is in the center, in power in the center.
no. What is the order passed by the court?
The embargo is that, my lord. I just read that.
Must be a reasonable restriction.
No, my lord, that is not reasonable because in respect of
Tomorrow
2020,
we can take it up tomorrow.
my lord, tomorrow better become infectious because today is the program.
Show the order. Let us
Yes,
see.
my lord. Kindly see.
If we find it reasonable,
Yes,
we'll
yes,
not.
my lord. Today, my lord, page number, internal page 10, my lord. That is the embargo. And program held today, sorry. And we get bail.
Persons who have been implicated in the criminal cases.
And we get bail, my lord. And the bail order is that there is no evidence to.
No. See, the names of our forwarded at the quoted below. 10 organized who have handed over to the police in advance so that the case of crisis. No. It is reasonable orders.
My lord, with deepest of respect, my lord, we get the bail order from
next
the
year.
High Court, my lord.
If there is a possibility, definitely.
My lord, otherwise, my lord, the highest political leader of the because of he's a only single MLA from that political and he is the highest leader. Every person who came to this field today, my lord, they are for this
public.
My lord,
of the public also.
we get in this respect of this case, my lord, we already get bail, my lord, and the court observation is very much clear. Court observation was there is no such involvement with this incident, my lord.
Tomorrow. Yes.
Lordship, I am.
Well, then matter become infectious, my lord. Kindly other is
for next year we'll see.
Tomorrow.
Lordship, I'm praying for upgradation, Your Lordship. It's matter regarding the death of 4 under trial prisoner at Baru.
Yes, you have been mentioning for a long
Lordship, I
time.
mentioned it last Tuesday, Your Lordship.
Almost 4 or 5 times you have mentioned.
Your Lordship.
You give, let us see, examine. Please call.
Appellate side daily list, serial number 1.
My lord, Mr. Obro Mujumdar is appearing in this matter. He is appearing in Honorable Supreme Court, my lord.
He is not available today.
I'm praying for not today, my lord.
Where is Mr. Kundalia?
Your Lordship, he has not reached the court yet.
Traffic jam. All right. It is submitted that the learned senior advocate who is appearing in the matter is not available today. The adjournment is sought for.
Serial number 2.
Serial 2, I seek small password because the certified copy is being filed again, separate copy. So they told it will be given today. First, they said it's expired. Second, when we filed, they said it will be given today. So seeking small password, Lordship.
What is the matter?
Lordship, it is this matter relates to Lordship. I was issued a pre-show cause notice. I replied to the pre-show cause notice with all documents, all judgment relied upon documents, everything. They issue me a show cause stating one line, your reply has been considered and not found satisfactory. I go before the learned writ court. My prayer was that the department should consider my reply. And we relied upon your Lordship judgment in 2 matters. Diamond Beverages, which was followed by the erstwhile single bench also, that the pre-show cause notice and the show cause notice, the issue has to be dealt with. The learned single judge Lordship passes the order stating, show cause you again file a reply. Pre-show cause, it is just an intimation. So the officer need not give any reasonings.
That is not.
I'll take you to the show cause, Lordship. It's a copy paste of DRC 1A. And we have submitted a detailed reply with all supporting, all relied upon documents, everything. Because it was a proceeding under section 74, Lordships. Lordship, Lordship, page 34, para 16 of the impugned judgment, Lordship, certain observations have been made, which is totally contrary to what this Honorable High Court.
But the thing is, of course, the learned judge is right in saying that the show cause notice doesn't suffer from the vice of lack of jurisdiction.
Lordship, my point was not on show cause. My point was my reply not being considered.
Where is your
Reply.
Where is the pre-show cause?
Lordship, pre-show cause starts at page 84. 84 is the form. 86 onwards is the pre-show cause. Lordship, they give this table that these are the 3 suppliers, and they write that they have been found to be non-existent, and you have to pay the amount. This is the pre-show cause. Only on the ground that their registration has been cancelled retrospectively.
No. Apart from that, they say they never existed, never conducted
Lordship,
business.
because they cancelled their registration retrospectively in 2024. Therefore, because they have already filed their returns.
Where is your reply?
My reply starts at, Lordship, 93. 93, 94 is the form. 96 is the index. And 99 onwards, the detailed reply starts. Lordship, I give all the invoice, e-way bill copies. E-way bill was also there. Vehicle numbers were there. I give all my relied upon documents. I give the status of the GST portal showing the return filing status of the suppliers. They have filed their GSTR 1 and payment return 3B also. I supply everything and I rely upon various judgments of this court.
They would have given you a personal hearing.
No, Lordships, no personal hearing.
At that stage, there is no personal.
There is no provision in the law for that, Lordship.
All right. Then where is the
Lordship, the impugned show cause starts at page 360, volume 2, Lordships. Lordship, may I place the first paragraph? The reply as furnished in response to intimation in 1A issued under reference is not found to be satisfactory and hence not acceptable. Hence, the following amounts are due liability for 23-24 until satisfactory reply payment of tax interest is made. And then it is the same. Lordship, my only question is, what more I can satisfy to that officer? I've given e-way bill copies, invoice copies, bank statement copies. I've relied.
Has he at least referred to your reply?
Let's say first paragraph, which I read. First paragraph. The reply is as furnished is not found to be satisfactory.
It's a cut paste of the,
But he has considered it. The reply is furnished, my lord. He was not convinced with all those documents.
that
But
he has
still,
to say.
but still, my lord, it is a show cause. It is not adjudication. My lord, there has to be.
Then the pre-show cause is provided for in the
My lord, it is me. If your lordship kindly says
But
that
then once in terms of section 74(5),
Five.
he thinks the assessing officer thinks fit to
issue a pre-show cause.
pre-show
My lord,
cause.
in fact, it's not a pre-show cause. If your lordship kindly reads section 74(5), the law, it says that intimation of liability. You may or may not clear. If you do not clear the liability, then you can give reply to that I am not liable to pay that amount. It is not pre-show cause. We are using that nomenclature pre-show cause. But if you
in the you are hereby advised to pay the tax as ascertained along with the applicable interest in full, failing which show cause notice will be issued. So therefore, he makes some
he
submission
has made some submissions.
that could have been dealt with at least.
My lord, but still, my lord, his reply was considered. But I believe, my lord, it's a fact that it's a copy paste. No doubt about that. But still, my lord, they were not convinced with the documents which he has given. My lord,
Let
still,
him issue a fresh show cause.
that
This
can be
intra-court appeal. by the writ petitioner is directed against order dated so-and-so in petition number so-and-so. The petitioner had filed the writ petition challenging a show cause notice issued under section 74 within bracket 1 of the CGST Act 2017 and WBGST Act 2017, read with rule 142 within bracket 1 within brackets small a of the rules for the financial year 2023-24. The learned single bench opined that a writ petition is not maintainable against a show cause notice. And in support of such conclusion, several decisions were referred to. It is a settled legal position that if the authority issuing the show cause notice does not suffer from the vice of lack of jurisdiction, the court seldom interferes in a show cause notice. However, the case on hand is peculiar on facts, which has convinced us to grant certain relief to the appellant assessee. Prior to issuance of the show cause notice, an intimation of tax ascertained as payable under section 74 within bracket 5, dated 10th July 2024, was issued to the appellant. In the said intimation, certain particulars were given, and it was stated that the appellant has claimed input tax credit against alleged inward supply of goods from non-existing entities whose registration has been cancelled. The intimation has advised the petitioner, appellant, to pay the tax ascertained, failing which the appellant was informed that show cause notice will be issued under section 73 within bracket 1/74 within bracket 1. It is not in dispute that the appellant has submitted a detailed explanation and also enclosed certain documents in support of their contention and relied upon various decisions. Thus, when the authority has thought fit to exercise his powers under section 74 within bracket 5, he is enjoined upon a duty to consider the reply before he takes a decision to issue a show cause notice. Under section 74 within bracket 1 of the Act. However, in the instant case, we find that the show cause notice dated 10th July 2024 is
Show cause is 8th August.
Is a replica of the intimation given earlier, and all that the assessing officer has said is that the reply furnished by the appellant in response to the intimation is not found to be satisfactory and hence not acceptable. The remaining portion of the show cause notice has been copied from the earlier intimation, and the show cause notice does not deal with any of the contentions which were raised by the appellant in their reply to the intimation dated 18th July 2024. Therefore, we are of the view that the authority should consider the reply dated 18/7/2024 to the intimation issued earlier, deal with those issues, and then proceed to issue a show cause notice. Only for such reason, we are inclined to interfere in the matter. Accordingly, the appeal is allowed, the order passed in the writ petition is set aside, and consequently, the show cause notice issued under section 74 within bracket 1 of the Acts dated 10/7/2024 set aside, and the matter is remanded back to the assessing authority to consider the reply dated 18/7/2024, and if if he still finds it to be not satisfactory, it will be open to the authority to proceed in accordance with it.
Lordship, just one point, Lordship. Para 21 of the impugned order gives certain observations on the merits of the matter, which was never argued.
Light of the above order, any
Petition is al-
observations made by the learned single bench touching upon the merits of the matter stand vacated.
Much obliged. And Lordship, show cause date is 8th of August.
8th of August.
8th of August.
This certified copy of the impugned order
Will be
shall
filed,
be
Lordship.
filed during the course of the
Due course. Much obliged.
Serial number 3.
In this case, my lord, we have filed the appeal because, my lord, there is no interim stay granted by the learned single judge.
We will ask them to file their affidavit earlier.
My lord,
Within a week or 10 days. And we.
my lord, the difficulty is, my lord, that there is a demand of more than 5 crores upon me. And my lord, all that we are seeking is a remand back. My lord, I will just specify the reasons, my lord, because my lord, this issue, my lord, on affidavit and we filing the reply, my lord, it cannot be adjudicated at the, my lord, the High Court level, my lord, because there is a serious violation of the natural justice. And the authority concerned needs to consider everything before, my lord, passing an order. But may I state my case, my lord, why it needs to be remanded back?
Where is it? See, if we grant an interim order, it will tantamount to allowing the writ petition.
No, my lord, kindly consider, my lord.
We will.
My lord,
advance-
all that I am seeking is, my lord, a remand back.
Has recovery notice been issued? You
Yes,
don't
my lord,
tell
it will
No,
be issued,
after
my lord. My
adjudication
lord,
order, he has
earlier,
come
my
up-
lord, one second. Earlier, my lord, on earlier occasion, my electronic credit ledger was frozen. My business came to an standstill. After 1 year of the passing of the, my lord, the blocking of the credit ledger, my lord, once it was my lord, the freezing of the, my lord, the electronic credit ledger was set aside. Only then I could recommence my business. He's a very young boy, my lord, of 27, 28 years old. My lord, now, my lord, it is very difficult for him to run his business if again some coercive action is taken and a recovery is made. Whether in
Earlier you came before this court,
Same young.
we same young boy,
yes, my
and we directed the documents, etc., to be supplied. It was supplied. He
And he
chose
was
to
al-
contest the adjudication proceeding, and it's better that you file.
no, my lord, kindly consider, my lord, two things, my lord. Why?
All opportunities.
No, my lord, no, my lord,
Cross-examination
kindly.
also provided.
No, my lord,
He said
kindly.
you asked for opportunities of cross-examination. That was also provided.
No, my lord,
Lordship,
kindly
this was
consider, my lord.
order.
No, my lord, kindly consider, my submission. My lord, your lordship directed it to be remanded back for two reasons, my lord. One is cross-examination. Second is, my lord, of prove the movement of the goods. Now, in my case, my lord, I transported the goods through several, my lord, 29 vehicles. Now, my lord, the authority concerned only examines 4 transporter. 1 transporter was examined prior to coming to this, my lord, division bench. 3 transporters were subsequently examined. Those 3 transporters were not allowed to be cross-examined. Secondly, my lord, your lordship only allowed the cross-examination of the supplier, and he gave a categorical, my lord, reply in the cross-examination that he has indeed supplied the goods
We
to
have
me.
placed the adjudication order
Sir,
before.
kindly allow me 1 minute. So, my lord, the concerned authority in the order says that he is mentally incapacitated to give a statement that he has supplied the goods to me and does his re-examination, which was not permitted by your lordship. Secondly, my lord, there are cross-examination to be allowed of the various, my lord, the 29 transporter. Only on the basis of, my lord, 4 transporter, out of which 3 are not allowed to be cross-examined, a conclusion cannot be reached that the goods were not supplied to me. Secondly, my lord, with respect to the movement of the goods, my lord, the goods are purchased within a vicinity of 8 kilometers, where all the goods are sold interstate. So, with respect to 2 vehicles, my lord, I give a comprehensive, my lord, the data as to through which checkpost, my lord, this goods have traveled. Because now there is a RFID in each and every, my lord, the vehicle, and it is tagged with the e-waybill system. So, it is possible to check the entire movement, my lord, across the country. If once the vehicle starts moving, it is possible to check. I have made several representations to the authority concerned who had issued the so-called notice to me that please verify the movement of the entire transactions which I have conducted. But he refuses to do so. So, my lord, only thing which he does is to examine 1 or 2 transporter out of the 29 transporter who has supplied the goods to me, and he reaches a conclusion that the goods are not supplied to me. The supplier who gives a affirmative, my lord, statement in the cross examination that he has indeed supplied the goods to me, he is called mentally incapacitated to give a statement. My lord, in such a situation, my lord, how do I establish that the goods are, and he is registered since 2014 from the VAT era, my lord. And at that time, his registration was granted on physical verification of his premises, because in VAT era, my lord, the process of registration was that without physical verification of the premises, the registration was never granted. And my lord, there is a broker, my lord, who has, my lord, enabled us to do the transaction. We requested the examination of the broker also. He is also not examined. So my lord, the officer cannot act as my adversary, my lord.
No, the more you make submissions, I think we will be inclined to dismiss the writ petition also, saying that you have to avail the alternate remedy. It is better that you file an appeal. All these issues can be thrashed out, and he'll be able to see whether sufficient evidence was there, what are the effect of the documents he has produced. Where is the adjudication order?
My lord, the adjudication order is on, my lord, page 395, my lord.
402 is the result part.
Adjudication order 395 onwards, my lord. Well, my only request is that the authority concerned should enable me to prove my burden of proof of movement of the goods, my lord. That is my humble request. And my lord, if he is examining 3 more transporter, then their cross-examination should also be allowed. And the other transporter who has sold the goods to me, my lord, who has transported the goods sold to me, my lord, those also should be examined. So if the authority concerned is doing the examination, it should be complete. My lord, the investigation cannot be half-hearted, my lord, where some evidence comes against me and it is utilized to adjudicate
He has
against.
given some 26 pages. What are the effect of this reasoning, etc. How to examine this on affidavits?
No, my lord, I am.
There is no point in keeping
My lord,
the writ
if
petition pending.
if I am supposed to prove the movement of the goods, my lord, unless the authority concerned helps me to prove the movements of the goods when the record is in the possession of the authority concerned. I do not have the record of all the vehicles, my lord. I had the record of the 2 vehicles, my lord, but the rest of the vehicles I do not have the record, because that RFID, my lord, the vehicle owner has changed. So he is also, the vehicle owner is also not in possession of the RFID data, my lord.
No, this Shyam Sundar Tiwari,
Yes,
he is a big accused.
my lord, he has given my lord, in the cross examination, he has said that my lord, kindly have a look at page
No,
357.
they are all hard nuts to crack, sir. These are crores of rupees of ITC fraudulent.
My lord, he may have conducted the fraud, my lord. I have not conducted the fraud. So if he's conducted the fraud, the tax should be recovered from him, not from me, my lord.
24/7/24 is the adjudication order. On what date you filed the writ petition? Was it within the period of limitation for filing?
Yes, my lord. Within the limit. But all that I'm saying,
And if you go before the appellate authority, they cannot
my lord,
initiate.
my lord, for going to the appellate
10%.
authority, my lord, he do not have the, my lord, the amount for pre-deposit, my lord. It is such a huge demand, my lord. My lord, I have established that the movement of the goods has taken place from my godown, my lord, which is the godown of my transporter. My transporter is also not examined, my lord. The transporter who gave a certificate, my lord, kindly have a look at, my lord, the certificate of my transporter who is not examined. So wherever, my lord, the evidence is in my favor, that person is not being examined. My lord, kindly have a look at the certificate of the, my lord, page 437. My lord, kindly for one moment, my lord, kindly have a look at page 437. 437, my lord.
Yes.
437. BGTC Logistic. He is my transporter for outward transportation, my lord. He has given a certificate. This is to certify that we have provided ARS metal with our services to transport physical goods to their respective destinations. The said goods were first received to us at our place of business godown 585 Ravindra Sarni near 8 number Tram Depot, Kolkata 3, and then loaded into our trucks vehicle from our place of business at Kolkata, and then we delivered the same as per instruction of ARS Metal. So, my lord, the purchase is...
But what he says is that Tiwari disowned the issuance of those tax invoices.
No, my lord, Tiwari has given, my lord, kindly have a look at the cross-examination of
Always
Tiwari,
if
my
you
lord.
want, let the writ petition be pending, then what to do?
My lord,
It's
my
better.
lord,
You are losing out on time. It is better that because this steel trade itself is very volatile, sir.
my lord,
At the young age, he shouldn't get tangled with all these fellows.
my lord, my lord, kindly consider, my
Quick
lord.
money doesn't stay, sir.
My lord, kindly consider, my lord, the so-called notice, my lord, was issued on the basis of, my lord, the statement of one transporter and SS Tiwari. My lord, SS Tiwari in cross-examination.
So, therefore, like you have transported in 100 vehicles.
Yes.
You can't be examining all 100. But at least they have examined a couple of vehicles and they found that one vehicle was disposed of and dismantled as scrap. And another one was deregistered. And 13 times the very same vehicle has been quoted. Another vehicle is re-registered in Rajasthan, converted into RJ something something. WB 23 so and so is of no existence separately since 29/9/18. Another vehicle by EVS or Rachana Prada, 2 times of so and so mentioned of, even after allowing.
My lord, what I am submitting is these are all inward transportation, my lord, which is within the vicinity of 8 kilometers. I am
All
saying,
right. You want the writ to be pending, we'll keep it pending. That's
my
all.
lord, all that I want is remand back, my lord, for movement, my lord, at least for movement of the
All
goods,
right.
my lord.
We have heard Mr. Vinay Kumar Sharaf, learned advocate appearing for the appellant, and Mr. T.M. Siddiqui, learned senior advocate appearing for the state. The order impugned is an order passed by the learned single bench by which interim order was not granted, but direction was issued to file affidavits. Having gone through, the appellant had impugned an order of adjudication in the writ petition, against which an appeal lies before the appellate authority. However, for certain reasons, the appellant has challenged the adjudication order by filing the writ petition. The learned single bench was right that in observing that that apart from the maintainability of the writ petition, if the matter has to be gone into on merits, the disputed questions of fact has to be adjudicated, for which affidavits have to be exchanged. We find no error in the observation made by the learned single bench. Therefore, the appeal is dismissed. The respondents are directed to file their affidavit in opposition within 2 weeks from date, reply if any within a week. As directed by the learned single bench, let the matter appear let them, as directed by the learned single bench, let the writ petition be listed in the monthly list of February 2025.
My lord, kindly at least, my lord, give a direction for expeditious disposal, my lord.
That is wrong.
And the point of maintainability is kept open. Your
Yes, yes, yes. Grateful.
Serial number 4.
So I'm filing the certified copy. Lordship, I got it yesterday night, that is why. Lordship, here I am against, the issue is regarding e-way bill, Lordships. My vehicle was detained at 6:29 p.m. and e-way bill was generated at 6:56 p.m. Because there are records which shows that the vehicle had gone for payment. Lordship, from the supplier's place up to the payment bridge, up to 20 kilometers, no way bill is required. So it was going through a delivery challan. At 6:29, the vehicle was caught by the department saying that these goods are going for supply. I am the receiver, Lordship. My supplier had sent the goods. At that moment of time, the supplier told the transporter, also gave a certificate that we have come for payment. We will go back. The way bill will be generated and the vehicle will go. The total demand was, Lordship, around 2 lakh rupees. We paid the amount under protest. The appellate authority says mens rea. Lordship, 30 minutes, Lordship, and delivery challenge. It is recorded, Lordship. Kindly takes page 108. Show cause notice. Lordship,
108.
108, Lordship. It is recorded in the show cause notice, Lordship. Serial number 1, Lordship, in between. The vehicle was covered with 2 delivery challan bearing number this, dated this, and 56 dated this. As claimed by the RTP, challan bearing number 24 was for the payment purpose. The vehicle was intercepted at 6 p.m. on 15/6. The payment was completed at 6:29 p.m. on 15/6. The last payment was taken when the vehicle was in the custody of GST department. And Lordship, waybill copy, the waybill copy is at page 80, is at page 91, Lordships. The waybill is generated at 6:56 p.m. on the same day. Page 91, Lordships. Bottom table, Lordship, vehicle details entered at 15/6, 6:56. So this document was also produced to the department.
Where do you get it?
Lordship,
15/6.
Lordships, 6:56. Lordship, it's a Lordship, during the payment from the suppliers to the weighbill is exempted.
No, according your theory is the vehicle was intercepted
On the weighbill.
for the when it is
On the weighbill. On the way to the weighbridge. Lordship, 30 minutes, Lordship, nothing.
Lordship, may kindly record, my lord. I only say, my lord, that there has been violation of the relevant rules and provisions of.
Where is the appellate authority, sir?
Lordship, appellate authority order starts at page 159. Lordship, the detail order starts at 161. And the discussion and finding starts at page 166. They have referred to all the judgment of chairman versus SEBI for mens rea, Lordship. So it is a case of mens rea. Page 166, Lordships. In this connection, following case law is cited in chairman versus SEBI. All the entire thing of mens rea has been, mens rea is not required to be seen under section 129, and therefore the demand.
You would have placed those judgments also.
Lordship, everything was there in the appeal paper book, Lordship. Appeal paper book at page 1.
In reply to his judgment, my lord, they had.
Lordship, my index is at page 136.
Page
136 is my index to the appeal. All the documents are also attached. Lordship, I placed the judgment of Gujarat High Court in Synergy FinTech and Medha Servo of this Honorable High Court.
where is that judgment?
Lordship,
Medha Servo.
Lordship, that judgment is at page number. Judgment ka copy. Nahi laya. Lordship, page 209. Here, Lordship had remanded the matter because the distance was within 6 kilometers. And the question that your Lordship had framed that whether mens rea was at all there or not. But in this case, Lordship, it is accepted that it is a 30 minutes delay, which is, Lordship may impose some small penalty in that case, a small time purchase supply recipe.
This intra-court appeal is directed against the order dated 16/12/2024, by which the learned single bench directed affidavits to be exchanged. At the request of the learned counsels appearing for the parties and with their consent, the writ petition is also taken up for hearing along with this appeal. The appellant had challenged an order passed by the appellate authority, namely the Senior Joint Commissioner of Revenue, Bali Circle, dated 5th October 2024, by which the penalty imposed on the appellant under section 129 within bracket 1 within bracket small a of the GST Act 2017 was affirmed, and the appeal came to be rejected. We need not labor much to examine as to whether the reasoning given by the learned single bench was justified or not. As on facts, we are convinced there cannot be an intention or much less a willful intention on the part of the appellant to evade payment of tax. We say so because the vehicle was intercepted at 6 p.m. on the stated date, when the vehicle was proceeding towards the weighbridge for weighment. After completion of the weighment, the e-way bill was generated on 15/6/2023 at 6:56 p.m. Even assuming that there is the delay, the delay cannot be construed to be one with a willful intention to evade payment of tax. Therefore, considering the peculiar facts and circumstances of the case, we are of the view that it is not a case where penalty could have been imposed on the appellant under section 129 within bracket 1 within bracket small a of the act. How much have you paid?
Lordship, I have paid full. The total amount which I have paid is, Lordships, at page number 159, it is disclosed, Lordships, 1,75,715. I have paid total as penalty, 1,75,000.
716. Huh? Then how will you get a refund of this?
Lordship, there's a process, Lordship. Once your Lordship passes an order, we have to file a refund application in the portal. There's an option in the portal that basis the High Court order.
Appellant, without prejudice to the rights and contentions, had remitted the penalty amount of rupees 1,75,716. In the light of the above, the appeal as well as the writ petition are allowed, and the order passed by the appellate authority dated 5/10/2024 and the order passed by the original adjudicating authority
Page 114.
date
5th of July 2023.
12th of July 2023 are set aside. The appellant is at liberty to seek for refund of the penalty amount which was remitted by them. And if such application is filed, the same shall be dealt with in accordance with.
Much order. Grateful.
Two matters.
No, next matter is same. It is regarding waybill, but different facts.
This is item 4. The certified copy of the impugned order.
Lordship, this also I'll file in now. Next.
Which is taken on record.
We'll file in the department next time onwards, Lordship. Today I'm taking liberty to just file for the next matter also.
What is item 5?
Lordship, item 5, Lordship, here the issue, Lordship, address, bill to ship to model. So from where I am taking, my supplier is located in X place, X pin code, and it is being directly dispatched to my customer. Now, in my waybill, because I do not want to disclose the address and name of my supplier for my pricing issues, I only give his pin code. I give pin code. I write Durgapur pin code this to hide my supplier's name. They say that on the verification of documents, it cannot be proved that it is the same goods. I am showing, Lordships. Lordship, may kindly take the first page 72. This is my supplier's invoice to me.
You can get a certificate from him.
Lordship, everything given on record, but they say it is Mensria.
72.
72 is, Lordship, my supplier's invoice. Showa International.
Showa International.
Dated 6/7/23 and dispatched through vehicle number 1508. And Lordship, it is written, details of receiver is my name.
Truth Udyog.
Truth Udyog. Now, Lordships, next page is the e-way bill generated by my supplier.
The Showa Enterprises, bank details, everything is
Everything is there. Next page is the e-way bill generated by Showa. Lordship, may verify the vehicle number in the part B below table 1508.
Yes.
It is generated on 6th of July, 7:19 p.m. Now, Lordships, page 74 is my invoice to my customer. Truth Udyog invoice to CRM Ispat, who is my customer. And Lordships, may kindly see the vehicle number in right hand side, page 74, 1508. My invoice, Lordships. Now, Lordship, my way bill at page 75. Now, Lordship, this is where the department says 75, Lordship, Part A. GSTN of supplier is my details. Place of dispatch, I have written West Bengal, this pin code only. To not to show my supplier's name.
The place of delivery.
Place of dispatch, Lordship. Part A, row number 2.
West Bengal, 713.
Now, Lordship, may kindly match this with page 72. Showa International's pin code.
713.
Lordships. So I just not for the purpose of not to disclose my supplier's name, we write only the pin code from where it is being dispatched. And Lordship, page 76 is the detailed way bill. Detailed way bill, Lordship, also dispatch from Durgapur 7131212 and consigned to CRM Ispat at Durgapur. So it was from Durgapur to Durgapur only. Within the distance of 20-25 kilometers. They say this is a willful misstatement that you should have given the details of your supplier to, and they have detained, levied 200%.
How does that amount to evasion of tax?
That is what the case, Lordship. They every time I'll take you to the appeal orders, Lordship. The appellate authority, every time a case of 129 is made, it is a case that it is a willful suppression, evasion of tax, Lordship. That is how the law has been done, Lordship.
Where is the
Lordship, the appeal order is at page 121. Lordship, the discussion and finding starts at page 129. The submitted documents are duly examined.
129.
129. Discussion part starts at the submitted documents are duly examined. Appellant submits that the appellant submits the statement of fact in annexure APL 1, in which he stated that he has purchased loaded goods from Mr. Showa Solar International at Durgapur by tax invoice dated this and related e-way bill, and the said goods were to be directly dispatched from supplier place of business. That is, transaction was executed from appellant supplier place of business without goods coming to the appellant premises and them being dispatched to the customer. Appellant further stated that e-way bill for movement of the goods was generated by Showa Solar International, bearing number this, having validity till this. Appellant further stated that way bill for movement was also generated by the appellant on 7/7 and having validity till midnight of 8/7. Regarding the above point, it is noted that said tax invoice 20 dated this shows the goods shipped to through Udyog, West Bengal, and the related e-way bill bearing number 2 shows the place of delivery as Belur Mart, West Bengal. As per the above details, goods shipped to through Udyog, Jagannathpur, Dankuni, and after that the goods have been moved to CRM Ispat, which is not the fact, which we told. It is direct, and therefore in the e-way bill, Lordships, kindly text my e-way bill at page 76. 76, Lordship. In the portal, there is a pro forma. If you have to do bill to ship to, how I will prove that, Lordship? In the page 76, transaction type. Right hand side, transaction type.
Bill from dispatch.
Bill from, dispatch from. So billing from Durgapur, dispatch from my suppliers. So there are 5 drop-down boxes in the portal. It can be bill to, ship to, bill from, switch from, bill to, dispatch from. There are 5 other permutation combinations given, Lordships. Lordship, the total amount in this case was around 2,65,000, Lordship. And they have stated that because of menstrual.
Oh, actually, this e-way bill, if you had to generate online.
Lordship, it is online.
If according to the portal, if you have to give the full name and address of the supplier alone, the portal will accept, then it's a different matter. But the portal has accepted this.
Lordship,
Bardhaman, West Bengal, 713.
Lordship, it's a trade practice because, Lordship, if I directly give my supplier's name, then next time the customer will directly be in contact with the supplier because these are trader persons. It's a trade practice, Lordship, in case of direct dispatch cases. Lordship, my only prayer is that these small cases were 129 because department every time, whenever they detain a vehicle.
No, in your explanation to the show cause notice.
Lordship, show cause notice at this stage that we have at the appeal.
No, sorry. Your appeal.
Appeal, Lordship. Kindly takes page 105 onwards, Lordship.
No, on this point.
On this point, Lordship. My facts I have noted, Lordships.
10?
Lordship, it starts at 107. My APL 1, the appeal which I had filed. The statement of fact starts at page 109 onwards, Lordships. And page 1111, serial number 8 onwards is my justification. Serial number 8, Lordship. The appellant said that the facts leading to a present case relates to mismatch of place of dispatch in e-way bill during the movement of goods and whether penalty under 129 can be imposed on the appellant on the above issue of place of dispatch and by ignoring the bona fides of the transaction in question and by ignoring the fact that the movement were covered with valid documents as required under statute. Then an extract what is Rule 138, Lordships, for e-way bill. Then, Lordship, para number 10, page 112, para number 10. The appellant said that Showa International issued a valid tax invoice for supply of goods and generated a valid e-way bill before the commencement. Appellant stated that appellant had generated a valid e-way bill for supply to the customer CRM by e-way bill number dated this, which was produced by the driver at the time of interception. Further, it is stated by the Adjudication Authority that as per the invoice bearing number this was verified and resulted into mismatch of place of dispatch. Para number 12. The appellant further states since the e-way bill was generated by the Showa International as per tax invoice this issued by Showa International on the appellant and the e-way bill bearing number 3062 where the place of dispatch shows Bardhaman. The appellant further stated in case of direct dispatch of goods from supplier to customer in order to avoid disclosure of detail of the supplier to the customer, the trade practice is only to mention the place of dispatch in dispatch from address rather than giving the total details of the supplier. Hence, at the time of generation of e-way bill from the appellant and it had mentioned West Bengal 71312 as a place of dispatch. The pin code of the same resembles the pin code of Messrs. Showa International and hence there cannot be any allegation of discrepancy.
There was no revenue leakage or 129 could not have been applied. Now what happened? Your writ petition dismissed.
Affidavit directions.
This intra-court appeal by the writ petitioner is directed against the order passed by the learned single bench, declining to grant any interim order, but directing affidavits to be filed, affidavits to be exchanged. At the request made by the learned advocates for the parties and with their consent, the writ petition as well as this appeal are disposed of by this common order and judgment. The short issue which falls for consideration is whether the appellate authority, namely the senior joint commissioner, Senior Joint Commissioner of Revenue, Bali Circle, was justified in dismissing the SSC's appeal by order dated 4/10/2024, confirming the penalty, order of penalty imposed on the appellant under section 129 within bracket 1 of the GST Act 2017.
72. ये पहला Showa International का member.
It's not clear as to how the adjudicating authority and the appellate authority had invoked section 129 of the Act. Since the facts of the present case shows there appears to have been no intention to evade payment of tax. The only reason for imposing penalty is that in the e-way bill, e-way bill generated by the appellant in favor of Messrs. CRM ISPAT Private Limited, capital C, capital R, capital M, ISPAT Private Limited, dated 8/7/2023 for outward supply. The
Give me 2 minutes.
dispatch was shown to be made from Durgapur, West Bengal, -713-212. The authorities are of the opinion that the full details of the company which dispatched the goods, which was sent to the appellant's customer, was not disclosed. However, on a comparison of the tax invoice, a comparison of the e-way bill raised on 6/7/2023, along with the tax invoice raised by the appellant, shows the goods moved in the same vehicle bearing registration WB 41D1508. The appellant's explanation before the authorities was that in cases of direct dispatch of goods from supplier to customer, in order to avoid the disclosure of details of the supplier to the customer, the trade practice is to only mention the place of dispatch in the dispatch from address rather than giving the total details of the supplier. Therefore, the appellant contended that in the e-way bill which was generated by them, it had mentioned only the place of dispatch as West Bengal 713212. The pin code matches with that of Showa International, the appellant's supplier. In any event, the e-way bill is generated based on an application made in the portal. And in part A of the e-way bill, one of the details to be furnished is place of dispatch, and in which the appellant had mentioned as West Bengal -713212, and this details which was disclosed while making the application was accepted and the e-way bill stood generated. Therefore, merely because the appellant did not disclose the full the name of the company and the full address of his supplier cannot be stated to be a ground that the appellant had intention to evade payment of tax. Thus, the peculiar facts and circumstances of the case, the power under section 129 within bracket 1 within bracket small a of the Act could not have been invoked. The above reason, the appeal is ordered. The order passed by the appellate authority as well as the original authority is set aside, and the appellant is entitled to apply for refund. You have paid?
I paid, Lordship.
Refund of the penalty which was remitted to by them without prejudice to the rights and conditions. If such refund application is filed, the same shall be dealt in accordance with the
Grateful. I apologize for that certified copy. Next time onwards, they'll file in it.
yes.
Grateful.
Yes.
The issue in this petition is, my lord, my writ petition is dismissed. And the
On
writ
ground of,
petition,
appeal, because
No.
appeal is available.
my lord, before the single judge, the writ petition was dismissed, my lord. My lord, the issue in this petition which was raised is, my lord, there are three issues, my lord. One is that, my lord, the so-called notice, my lord, demanded, my lord, sought a reversal of ITC only on the ground that there is a difference between GSTR 2A and 3B. There was nothing, my lord. It is the so-called notice itself is only in a tabular format. There is no reason whatsoever. They refer to 2A, 3B, and they said this is the difference, and you paid. They do not cite any reason whatsoever as to, my lord, the difference between GSTR 2A and 3B may give rise to some suspicion. But, my lord, at that point of time, my lord, as the law existed at that point of time, my lord, the rule 36(4) had come. But, my lord, rule 36(4) was issued by drawing power from section 43A. Section 43A was never notified, my lord. And thereafter, my lord, in 2022, section 16(2) AA was inserted, which was identical to the wordings of section, rule 36(4). So, effectively, the effective date of rule 36(4) is from 1/1/2022, and for the period in question, my lord, when the rule 36(4) was there, my lord, where the difference between GSTR 2A and 3B could have been the basis for raising of the demand, my lord. So that is why we had, my lord, challenged it retrospective, my lord, the validity of rule 36(4). Because my submission is that the so-cause notice, my lord, in any which case, my lord, even today, my lord, the so-cause notice cannot be issued merely on the basis of, my lord, reconciling the DSTR 2A and 3B, my lord.
But
There must
then-
be something more.
But then you had given a reply to the show cause notice.
Yes, I have given a reply. I have stated that this could not have been the reason for issuance of the so-cause notice, because at the relevant point of time, the rule 36(4) never came into operation, because 43A itself was never notified. But that is point number one, my lord. Second point, my lord, is with respect to liability to pay on reverse charge mechanism, my lord.
Hmm.
There, my lord, under reverse charge mechanism, my lord, the tax can be liable to be paid on 16 for 16 variety of services. But again, here, my lord, the so-cause notice merely states that you are liable to pay RCM. It does not state why. But once I submit my reply that you please tell me as to why I am liable to pay tax on RCM, then, my lord, the reason comes out in the order. That also, my lord, it is not tenable. But, my lord, as per section 75, subsection 7, order cannot travel beyond the so-cause notice. The reason for issuance of the notice as to why the concerned officer feels that I am liable to pay tax.
In your reply, you had contended
Yes,
from page 100 to 103
correct.
that show cause notice is vague
Yes, my lord.
because there are as many as 16 category of services
Correct.
and they have not specified. How has he dealt with this ground?
Yes, my lord.
Original authority. But where is the adjudication order?
My lord, order in original, my lord. Page 67, my lord, onwards. Page 72 is, my lord, the operative part. Page 72 onwards. My lord, may I read out, my lord?
1 second. No, he says for preparing a perfect show cause notice, the undersigned required reply from the RTP, which he refused to provide.
No, no, my lord, there is no refusal to provide. My lord, I have repeatedly, my lord, I have once.
Considered not only GSTR 2A, 3B, everything, my lord. And the railways provides parking services, my lord, is
My lord, I provide parking service to the railways.
KMC. Intentionally, my lord, he has not implicated the railways and the KMC's parties. My lord, we have taken into consideration from the railways the reverse charge mechanism. They have also stated that. Your lordship kindly comes to page 74. Starting from page 73. 73, my lord. Discussions and conclusion. The penultimate paragraph.
My lord, my submission is that the so-cause notice, my lord, cannot partake the character of investigation, my lord. Prior to that, my lord, the authority concerned has the
No,
power to.
You are a cooperative society
Yes, my lord.
and you have been rendering or supplying some services,
Parking services, my lord.
whatever services.
Yes, my lord.
You should know under which category. You have taken a GSC.
My lord,
CGST.
my submission is that I am not liable to pay tax under RCM. He is saying, my lord, kindly have a look at his order, my lord.
No, you file appeals.
My lord, kindly consider, my lord, he cannot travel beyond the scope of so-cause notice, my
That
lord.
is a good ground to canvass in the appellate authority.
My lord, section 75, my lord, kindly have a look at section 75(7). But can he raise a ground which is not there in the so-cause notice, my lord?
He says, now the RTP has issued intimation on 9/1/24 with the statement of facts as per his returns and statement for the said return period. He has unpaid liability under RCM. RTP was aware of said intimation. No reply has been filed by the RTP against intimation. RTP is also aware of the fact that he is liable to pay tax under RCM during filing his returns for the said period and during the transaction with supplies of charge zones. Now, once the intimation comes, you could have said that this is not a taxable service.
My lord, that also I have stated in my reply. My lord, that I have stated in my reply. And my lord, I have not been given an opportunity of hearing, my lord.
This
My
is
lord,
just-
my lord, kindly consider, my lord, my authorized representative appeared repeatedly. He is saying that the person concerned who has authorized you, he is not entitled to authorize you. Where is the person who has authorized me is repeatedly, my lord, signing the return. He is also the authorized person in the website. But I should have been given an opportunity of
there is
hearing, my lord.
if there is even a 10% chance, definitely we will enter. It's not that you don't know. No? Item 27 is also same assessee.
No, my lord, that is a different matter. 20,
Same assessee we said.
my lord, the party is same, but the issue is
Same assessee. We're not saying same.
SSC is same.
We have heard so also. This intra-court appeal is directed against order dated 2012.
My lord, kindly consider, my lord, there is
We'll
a
extend
challenge.
the time for filing appeal.
But kindly consider one thing, my lord. There is a challenge to retrospective validity of Rule 36(4), my lord, which cannot be raised before the concerned authority. But it can be only be dealt with by, my lord, this Honorable High Court.
It is unnecessary, sir.
But because it is a...
You are unnecessarily prolonging the agony of the assessee. You give up that prayer. Quashing the order under 73, certiorari to quash the show cause notice, staying the order under 73, declaration of rules 36. We will give liberty for you to separately challenge the rule. This intra-court appeal by the writ petitioner was directed against the order dated 20/12/2024, by which the writ petition filed challenging an order of adjudication passed under section 73 of the CGST/WBGST Act 2017 was not entertained, and the appellant was relegated to file an appeal as provided under section 107 of the CGST Act. After elaborately hearing the learned advocate for the appellant and the learned senior advocate appearing for the state, we find that several disputed questions of fact have to be
kindly, my lord, kindly relegate me to the authority. I will make my submission afresh. My lord, whatever, my lord, the order has been passed, it can be considered as a so-called notice, my lord.
questions of
So that,
fact have
my lord,
to be
I have an
not
opportunity to
adjudicated
reply,
in
my
the
lord.
petition based on affidavits. Therefore, the learned single bench was right in relegating the appellant to the file a statutory appeal. Mr. Sharaf, an advocate appearing for the appellant, submitted that one of the prayers sought for in the writ petition is to declare Rule 36 within bracket 4 of the CGST rule in 2017 as what is the prayer? Illegal. So as unconstitutional. This it is no doubt true that such a prayer cannot be made before the appellate authority. Therefore, we leave it open to the appellant to challenge the rule by way of a separate writ petition, and we are not inclined to interfere with the order passed by the learned single bench, relegating the appellant to file a statutory appeal. Full stop. If the appellant files the statutory appeal within a period of 30 days from the date of receipt of the server copy of this order, the appellate authority shall not reject the appeal on the ground of limitation, but proceed to take a decision in accordance.
My lord, kindly consider, my lord, I have not been given an opportunity of hearing also, my lord. May I be given an opportunity of hearing, my lord? A fresh order may be passed.
Let the appellate authority consider. Next.
Serial number 7.
Item number 7, Mr. Bikash Ranjan Niyogi is appearing, my lord. He has left court today because his family member has suddenly become sick, my lord. If I'm praying for a day's accommodation, my lord.
Senior advocate is appearing for the second time today.
I'm not standing in
My lord, he has suddenly left.
standing in the way. Prayer, Lordship. Only one thing. The special officer's inquiry is being by the and tomorrow is the date for inquiry. I will not trouble your honor, Lordship, with the charge. Your Lordship kindly consider 92 only. How heinous it was, nothing.
No, tomorrow what cross-examination has to be done?
It has to be, yes, process.
Let him proceed. As DP will not get concluded. Where is the charge memo?
90 is the charge memo, 92
Lordship kindly consider. Thank you. The articles of charge number 1. This is the theme. Criminal case was instituted and somehow order has been passed. Lordship, I am not standing in a way. Give us order. Lordship,
And he is a civil judge, senior division.
kindly consider the single bench order 118. An innocuous order. Within such and such time, it has to be complete.
My lord,
Teacher.
Even if your client had been acquitted in the
my lord, I
convicted,
am not the advocate on
he is occupying a post of such a post.
my lord,
and
I am not the advocate on record in this matter, my lord. That is why there is difficulty, my lord.
Tomorrow is the date for inquiry, where for the last occasion he has said that I will not give any witness in my defense. The cross-examination will start tomorrow.
Adjournment is sought for on the ground that the advocate appearing for the appellant is not available. The learned advocate appearing for the High Court, respondent, senior advocate appearing for the respondent submitted that the inquiry officer has fixed the inquiry tomorrow, that is 22/1/2025. The pendency of this appeal will not be a bar for the inquiry officer to proceed with the inquiry, and the appellant is advised to participate in the inquiry proceeding. 3 weeks. Next.
My lord is adjourned. No, my-
Adjourned. Next.
Serial number 8 and 9.
One small suggestion, AG.
Yes, Mr.
Can we just run through the contempt applications and then take up?
Or your lordship takes it up at 2 o'clock, subject to your lordship.
Any other day to today, I will not be here. Or if it can be Friday.
This Friday.
No, Friday, original side matters. at least.
Already one matter is partly heard.
Then lordship, next Tuesday, if it's for. Next Wednesday,
Division.
Wednesday or Thursday, whichever day.
Wednesday.
Next Wednesday.
AG subject to AG.
Next Wednesday, ठीक है?
Sir, अपना होगा तो
Yes, yes. Yes, yes.
Already. 10 and 11.
Well, there's a delay. I don't know whether my learned friend is opposing or not.
Contempt says, lordship, I have to oppose. Lordship will apply my lord's own view.
All right. At the request of the learned advocates on either side.
The Supreme
It's
Court
on,
contempt says.
29th. In the same position.
Well,
8 and 9. First, we'll have to hear the review.
yes.
And first the delay in filing the review and then the review.
Yes, yes. If at all delay is a point in review, in the jurisdiction.
Okay. Then next,
Serial number 10 and 11.
this is that issue where whether
Dalmia,
appeal is
review,
needed.
review.
And who will appear for the respondent?
Mr. Mr. Muzumdar was there, but there was a point as to whether the rejection of a review is appealable, intra-court appeal is available or not.
Because his lordship is hearing another matter.
Yes.
This matter. This only.
No, this matter was being heard by the other bench with Justice Bhattacharya as part of it.
We'll post it in that bench because his lordship has framed the question. Justice Tandon.
Yes, Justice Tandon has framed the question, and I don't think whether I should say this or not. Justice Bhattacharya has made some research also.
And he would have discussed it with Justice Tandon.
Then all of us.
All right, item 10. let the matter be heard. No, since one of us not inclined to take up my name. And papers be placed before the Chief Justice for appropriate. Let it come. Okay. Next.
Will it appear here, my lord?
It will appear. Today the file will come to me.
Because my lord, we are in a hurry. So whatever may be the outcome, my lord.
Right.
Very well.
Serial number 12.
Number 12, I beg to appear on behalf of the petitioner, Lordship. That is the contempt application, Lordship. Last occasion matter appeared before your Lordship. On that occasion, Lordship, please to date us to serve the copy to the government pleader. We have already served the copy
Yes,
to
sir.
the government pleader, Lordship. That's my repeatability.
Yes, sir. What is your instruction? Complied with, not complied with?
That means that, my lord, regarding this, my lord, one review application filed with your Lordship.
Where is that?
That is, my lord, RVW number 1 of 2023. So far, my lord,
On what ground you want to?
my lord, your Lordship directed that the tender which has been floated, that is done by the
Joint Forest Management Committee.
But regarding that, my lord, so far, my
There
lord,
will be a direction to the concerned forest officials of the Directorate of Forests to ensure that the annual general meeting and elections and the executive committee,
my lord, I have to take instruction whether that has constituted or not.
nothing has been confused.
In this regard, I have to submit before your Lordship that there was the specific direction by this government of West Bengal also.
No, you
that
please
the
show
forest-
the review. Get that file. Where is your review grounds?
My lord, review RPW number.
You show the review application.
Application আছে review application এর xerox copy আছে আপনার কাছে
But the difficulty is that the order was passed, the e-tender was issued, and the private contractor already called for that. But that should not be, Lordship. That's the order of this honorable court, Lordship. Only by the plantation should be given only to the Joint Forest Management Committee, not to the others, any of the parties.
But there is a direction of the state government that regarding above 1 lakh, up to 1 lakh, my lord, it can be done, but above 1 lakh, where there is above 1 lakh, my lord, that's why, my lord, it cannot be.
Lordship, please to consider.
One second, sir. One second. In the review grounds, you are canvassing a case which was never placed before this court. How to review the order on a grounds which are not can. You could have filed an appeal to Supreme Court. Yes, we have not gone anywhere. And there, even in the review, there is nothing to point out that the government order dated 11th December 2019 stood superseded. But in your grounds in the review, you have said that there is a notification of the Finance Department in July 27, 2022, whereby the WBFR was amended. And it was declared that in a case of tender value of 1 lakh or more, e-tendering through centralized e-tender portal is mandatory in addition to. If you want, you can split a single tender into 3 to avoid e-tender.
Yes, yes, sir.
Your officer knows better.
Yes.
You can split it into 10 also, depending on whom to give. Mr. X will be given 3, his wife will be given 3, his brother-in-law will be given 3, brother-in-law's wife will be given 3. Sum total, if you put together, it will be a 10 lakh tender. No, you comply with, do something. Review, there is nothing, sir. Sir, we can test the correctness of the order if you are able to point out a error which is apparent on the face of the judgment. The grounds.
The second part of your lordship for that regarding the committee.
No, that we will grant you time to get proper instruction.
Don't take the such instruction.
You get the review of file.
But they have already issued the e-tender on 16th of July 2024. Order was passed on 11th of April 2023, Lordship. One after one e-tender passed by them, Lordship. And it is a specific order by this Honorable Court, Lordship.
On what date you filed the contempt application?
19th June, Lord. 19th July 2023.
RVW so and so, can 1 of and can 2 of 2023. RVW 186. This application, the review application has been filed to review the judgment and order in WPAP 274 of 2021, dated 11/4/2023. We have heard the learned government counsel appearing for the appellant state review applicant state and the learned advocate appearing for the respondent petitioner. The review is there is a delay of 136 days in filing the review. On going through the affidavit, we find that proper explanation has not been given for the delay in filing the review. That apart, we find that the review application was filed on 28/8/2023, much after the filing of the contempt application. Application, which was filed on 19/7/2023. That apart, further we have gone through the grounds of review and we find that the review applicant state is attempting to set up a new case which was never placed before the court when the writ petition was disposed of. Thus, unless and until the applicant is able to point out an error which is apparent on the face of the judgment and order, the question of entertaining a review application that do on the grounds which are never canvassed by the state can be entertained. For the above reason, the review application dismissed, applications are also dismissed. The next paragraph, in CPAN 982 of 2023, the respondent alleged contemnor had filed a review application, which was dismissed by order dated 21/1/2025. The time for compliance of the directions issued is extended by 3 weeks from date. Miss the matter after 4 weeks. Next,
And subsequent e-tender should be stayed, Lordship. That's the repeated reference, the
we'll
subsequent.
see. Next,
Serial number 13.
Grateful. And I'm praying very short indulgence. One supplementary affidavit may be allowed to file the e-tender already issued in this matter, Lordship, one after one.
you
Then
bring the affidavit on that day, we will see.
grateful, grateful.
Item 13,
I am for the petitioner.
And for the alleged contempt of 1 and 2, madam. Article Lordship,
My lord, and road, village road, Moram Road that was constructed in 2009. Persons of 3 village, my lord, they had been using the same with ambulance and other facilities. Now 2014 onwards, my lord, illegal very.
funds have to be sanctioned by the block development.
That's the claim of the Pradhan.
Okay.
So there is a direction by the BDO, you do it yourself. And DM was
Directed affidavit to be filed
is by the Pradhan.
by the Pradhan.
Pradhan and my lord, Secretary of the Gram Panchayat.
Where is the affidavit?
No, affidavit is contempt of 1 and 2.
And sir. Paragraph 10 sanction. Which is February. Yes.
So now the tender has already been floated.
Fund has been sanctioned, already sanctioned.
51 lakhs 23,000.
Page 19, my lord.
So now as on date, you have made some repairs, but on either side you have to do the piling.
Water bodies both sides, my lord.
And those bhedis are illegal bhedi that has been created.
Pardon?
Those are the bhedis, water bodies. Those are being used as a bhedi mal and that's illegally created.
But so much water is there. Where to pump
Yes,
out the
yes,
water?
yes.
What they can do is, we will direct them to proceed further in pursuant to their, sanctioned, and the said work schedule has been uploaded in the government portal. What is that?
I pray before Lordship kindly keep this contempt petition pending. Let them proceed with the work and let me take instruction because my instruction is otherwise. They have sanctioned this fund. But my lord, they are not touching this road, which is the subject matter before Lordship.
Then
It's
you
a
do
village road that is being created, touching a portion or a point of this road. But this is the road through which my lord, villagers of 3 villages, they have to come before the my lord.
Where is that photograph?
May I hand it over to your lord?
According to you, this is not the road.
That's a portion.
Portion.
This is not being constructed. They have sanctioned fund. Kindly go to the next page. This is a recent picture of the last week. And we can't, we have to use dolly, which is known as palki or dolly, to bring any patient to the hospital.
4 feet road, my lord.
This is not 4.
It's no more 4 feet at present.
The bicycle can't go in this. But unless you do the piling work on both sides, how much ever you repair the road, it will get washed off.
Well, let the authority take steps. Let them take steps, my lord.
All right. Enough. In terms of the directions issued earlier, directions issued on 17/12/2024, the affidavit has been filed by the secretary of the Gram Panchayat. Among other things, it has been stated that in order to strengthen the road, the Gram Panchayat proposed piling guard, and the proposal was accepted, and funds of rupees 51,23,266 has been sanctioned by the competent authority, and the said work schedule has also been uploaded in the government portal, namely GP Wise Patashri for the year 2024-25 under serial number 163. It will not be sufficient here just to upload the though funds might have been sanctioned, it is the authorities who have to implement and complete the work at the earliest. The photographs which were placed before this court by the learned advocate appearing for the applicant shows that it is not a road, but it is only a pathway which is now in existence, and there are large water bodies on either side. Thus, the piling work is required to be done in a proper manner so that the width of the road can be maintained to at least minimum of what was the original width? Width.
That there is two things. Is Sudhir Bhomik to Ranjit Bhomik. That's the lane. No, original width was my lord. It's a 7 feet wide road.
4 feet. Detached.
Readable
stated 4 feet.
4 feet, that's usable.
Maintained, maintained, and the people of the three villages can commute through the road. At present, the photograph shows to be only a pathway where even a bicycle cannot be conveniently taken. The further action taken by the block development officer, the action taken by the block development officer pursuant to the sanction of funds be filed in the form of a report on the next hearing date. Let the BDO file a report.
Serial number 14.
With secretary as well as the Pradhan of the Panchayat. 4 weeks. None appears for the applicant. Even on the last occasion, none appeared for the applicant. Thus it appears that the applicants are not interested in pursuing the matter. Dismissed for non-person. Next.
Serial number 15 and 16.
I do appear for the applicant of the contempt application. Is a case of unauthorized construction on a public road. Now, on the 18th of April, that's the order under contempt, your lordship was pleased to direct the SDO to consider my representation
They
and
filed a review application. Where is the review?
But I have not been served with the copy of the.
we have also not been served.
Copy of the contempt application.
Contempt we have served. Which?
This thing has come up.
No.
Order and the forwarding letter.
You have filed the review.
I have filed the review.
On what ground?
My lord.
Review is time barred, no section 5.
My lord, there is a section 5 there are two applications, my lord. There is a section 5 application.
All right. What is the direction? How are you agreed?
Within 12 weeks, we have to consider and dispose of.
So, my lord, there are twofold items. First of all, my lord, the petitioner who has filed the public interest litigation, he has not at all filed it in public interest, my lord. Because I have annexed with my stay application, my lord, certain documents that shows that with the relatives of the petitioner, there are pending litigation before this honorable court itself, my lord. I have annexed with them with stay application. This is my first contention. And secondly, my contention is that on law.1, my lord, the SDO cannot consider the decision of encroachment, my lord. It has to be the decision, my lord. These are the two things, my lord, of my review application.
And who is the review applicant?
The review applicant is against whom the unauthorized construction is being alleged, my lord.
All right, we will discharge the petitioner. Still the authority can examine.
My lord, we had
There's a-
started, we had entered into the exercise. My lord, it continued for some time upon both the parties being called on. At that stage, my lord, when we got the information of review, my lord, one mistake has been committed. I should not, should come clean, my lord, that the proceeding has been kept in abeyance till the disposal of review. That should not have been done.
Suppose the SDO is
Yes.
of the view that he does not have jurisdiction,
Yeah.
he can forward the file to
Yeah,
the
my lord,
district.
it has been forwarded from the district magistrate to SDO to complete the exercise.
This review application has been filed to,
Real section 5 application, my lord, I have already filed it.
yes, to review the order and direction issued in WPAP 161 of 2024 dated 18/4/2024. The review applicant is the seventh respondent, was impleted seventh respondent in the writ petition. While disposing of the writ petition, the court did not enter into the merits of the matter, and therefore the review applicant cannot be stated to be aggrieved by the direction issue, which was only to direct the authorities to consider the representation. In fact, the subdivisional officer was directed by the district magistrate to go into the matter, and therefore the review applicant is precluded from contending that the subdivisional officer does not have jurisdiction, since he has been authorized by the district magistrate to initiate necessary action and submit the action taken report to the district magistrate. The review applicant submits that the writ petitioner is not a genuine public interest litigant, and there are several cases against him. Even assuming without admitting that such submission is correct, that cannot be a ground for the authorities to not to take action as and when it comes to their notice about any unauthorized construction. In fact, it is the authorities who have to keep vigil of the area, and they are empowered to take action by themselves without waiting for any representation or court orders. Therefore, full stop. Hence, since we have heard the learned advocates for the parties on the review application, the delay in filing the review application is condoned. However, we are not inclined to entertain the review application to review the order and direction issued in the writ petition. Accordingly, review application dismissed. The subdivisional officer is directed to proceed with the inquiry and pass final orders. That is in the CPAN. It's before that you say. So we have heard the learned advocates for the parties. The seventh respondent in the writ petition had filed a review application in RVWM also to review the order and direction issued in WPAP 161 of 2024, which was dismissed by order dated 21/1/2025. In the light of the same, full stop. The Learned Government Council submitted that the authorities have already initiated action, and the subdivisional officer is seized of the matter. However, the matter was kept in abeyance because the review application is pending. Now that the review application has been dismissed, the subdivisional officer is directed to proceed in terms of the directions issued in the order dated 18/4/2024 and WPAP 161 of 2024. Issue notice to the writ petitioner as well as the seventh respondent, and take action in accordance with the law within a period of 8 weeks from the date of receipt of the
There are only two things.
Eighth respondent maybe, my lord.
eighth respondent.
Only two things. The first, may I have a copy?
Yes,
May I have a copy of the review from the, so that.
But I will
and-
serve that. I will serve it.
Yes.
Give us with the copy of.
And another thing is, in
Okay.
the review, I was not briefed since I had not the copy.
all right.
My,
We have heard Mr. Sonsal and Government
All right.
Council for the official respondents in the review application, and his appearance may be regularized.
My lord, only
My
one
lord,
thing.
affidavit of service, my lord, pursuant to earlier direction, my lord, be kept on record, my lord.
My lord, may permit while hearing of may permit me to raise the point of subdivision authority being not being the authority. I want to raise the point.
It is made clear that the 8th respondent in this contempt application, who was the 7th respondent in the writ petition, is at liberty to canvass all issues, both factual and legal, before the concerned authority.
Great.
Next.
Serial number 17.
The contempt review both disposed.
My lord, I am for the petition. My lord, pleased to pass an order on 4th July 2024 at page 39, my lords. The direction on para 7 and 11 at page 42 and 43. Direction is on page 42.
Illegal mining. They were directed to conduct surprise inspection.
Now, my lord, there was a in details direction from your lordships. Now, a committee is to be formed and then steps to be taken. And my lord, the second part was that with regard to my lord that variation of that road, alternative route. Now, my lord, the through my lord WhatsApp, I'm very sorry, my lord, through my lord text message today I received. My lord, the second paragraph, lordship, kindly have a look. That my lord, till date, my lord, there is no my lord the contempt, my lord, no violation of my lord's order. It is under process. Because it will take some time.
Yes,
but the steps have already been taken. The committee has been formed with 10 members, headed by the my lord.
How much more time you require?
My lord, there is no such instruction, but 150 files they are my lord the scrutinizing.
No,
with regard to the minors.
did we fix any time limit?
No. There is no time limit.
You will record your instruction and we will say that you proceed further. This contempt application has been filed alleging willful disobedience of the order and direction issued in WPAP 355 of 2023, dated 4/7/2024. Paragraph the order reads as follows. Please
My lord, I personally visited 2019 that place. I know that alternative road has been made. It's my personal experience.
It takes time, sir. Land Government Council has produced a copy of a WhatsApp message received from the authority, which is to the following actually. You can quote this one. Thus, it is seen that authorities have already started implementing the direction and considering the as stated, the process may take time since since the files and documents of 150 almost 150 minors have to be examined. Therefore, we direct the authorities to proceed earnestly and to redress the grievances expressed as expeditiously as possible.
Grateful.
My lord, can you specify some time, my lord? Then there will take long time.
A period of 4 months from the date of receipt of server copy of 4 months.
Grateful, lord.
Serial number
Affidavit service to be
Affidavit
kept
of service kept on record.
Serial number 18.
I'm for the petitioner, Milord. This was an allegation with regard to the encroachment of a public road, Milord, and also public drain. Milord, at page 21, your lordship has passed in order, Milord, on 27th June 2024. Milord, Milord, the corporation authority, Milord, informed that they are taking steps. Your lordship directed the all process to be completed within a certain period.
May I get a copy of the order? No. Their submission was, your client, this is not a genuine public interest litigation.
So, Milord, kindly see page 2 of your lordship's order.
That's it. Be that as it may,
Since corporation is already seized of the matter, the second and third respondent are directed to proceed in accordance with law after issuing notice to the seventh
And
respondent.
what happened?
Thereafter, Milord, twice inspection was done.
Given a copy of the
Yes, I shall. Milord, twice inspection was.
Take instructions regarding. Any oral instructions you have got?
Milord, I have annexed. Milord, I have annexed. Twice inspection was being done upon notice. One hearing date was fixed.
Application may be served.
Yes, I shall give. Milord, your lordship sees, Milord, the.
Yes, they have implemented. No, they are proceeding further.
No, Milord, twice inspection was done. my lord, I have been asked for an hearing. That was done, but my lord, they have not, my lord, passed any order to that.
They will pass.
I
will
will- That's why, my lord.
This contempt application has been filed alleging that the respondent corporation, namely Howrah Municipal Corporation, has not complied with the direction issued in the writ petition. This appears to be incorrect on the applicant's own showing, as already notices have been issued on 19th July 2024 and 9th August 2024. Which shows that the authorities are proceeding further. While disposing the writ petition, time limit of 3 months was given. It appears that in the facts and circumstances, this time is insufficient. Therefore, we direct the municipal authorities to conclude the proceedings after hearing all concerned and pass appropriate orders within a period of 8 weeks from the date of receipt of the server. Extended 8 weeks. Grateful. May a copy be served on? Yes, please give, sir.
Yes, my lord, here and now I shall give. My lord,
Next.
Serial number 19.
Great.
19, I am for the petitioner, my lord. This is the first time, my lord, appear.
What is the contempt?
My lord, order dated, my lord, page 26, my lord. Page 26, order dated 1st August 2023.
Then what happened after this order?
And operative part, my lord.
No, we read the order. What happened? He has already initiated actions, sir.
My lord, thereafter, no further proceeding, my lord. No demolition, the illegal, unauthorized construction, my lord.
Probably they have filed an appeal against this order, subdivision magistrate's order. We don't know.
No further step, my lord. Only, my lord, only hearing, my lord. Thereafter, no proceeding, my lord.
So if the already notices have been issued under section 4(1) of the Public Premises Act. Overnight, you can't throw them out. Procedure has to be followed. Where is the contempt? This contempt application has been filed alleging willful disobedience of the order and direction issued by this court in WPA number so and so. On the petitioner's own showing, it is seen that already the subdivision magistrate Durgapur has initiated action and orders were passed on 14/6/2024, 4/7/2024. In the said order, the BL and LRO additional Durgapur Faridpur block was directed to serve notice to demarcate the portion of the land as per his report coming under Kaitan number 1. Apart from that, the order shows that action is being initiated under the West Bengal Public Land within bracket eviction of unauthorized occupants bracket close Act 1962. Therefore, we find no willful disobedience of the direction, but however, we direct the authorities to earnestly proceed with the matter and take the matter to a logical end after following the appropriate procedure under the said enactment. Next.
Serial number 20.
20.
20, I am for the petitioner, my lord. My lord, page 20, my lord, ordered order, my lord, and order dated 22 February 2024, my lord.
No inspection conducted.
I did number 21, my lord.
Serial number 20.
Sorry, my lord. 21 है देखिए আমাদেরটা দেখতে এটা তো বলছি इसके आजगार
20. It's the same matter.
Yes, my lord. Another, my lord, petitioner same, my lord. Matter is another, my lord, and another order, my lord.
And what happened after the order?
My lord, no step, my lord. Only, my lord, communication letter, my lord, page 21, my lord. Thereafter, After communication the solemn order, my lord, respondent authority did not pay any heed of the solemn order, my lord. Up till now, respondent authority, my lord.
All right. The learned advocate for the applicant is directed to serve notice in the office of the learned government pleader as well as the Durgapur Municipal Corporation. The alleged contemnor also have to be served. In addition, the learned advocate for the applicant shall serve the learned advocates who appeared for the alleged contemnors in the writ petition. Alleged contemnors who are the respondents in the writ petition. 3 weeks.
3 weeks.
Serial number 21 and 22.
My application. The matter pertains to a PIL filed by the petitioner, wherein during the pendency of the writ petition, similar find that the respondent number 6 has granted mining lease, where he supposed to cannot. But I will show.
Who will appear for the respondents? Assistant Additional Advocate General appeared for the state. Shaunok Mitro for 11th and 12th respondents. Sri Kumar Chakraborty respondent and Mr. Om Narayan Rai for CEAC. You have served them?
Yes, Miller. These are affidavit service.
Where are they? They are not attending court today. You have served notice on the advocates or?
On the advocates.
We'll pass over the matter. You informed them. Informed pass over. Oh, it's coming.
In item 22.
21, 22.
In item 22, my lord, I am appearing on behalf of the state. I don't know, my lord, about the
Scan application is specifically in the item number 21. This 21, 22 both are similar. No, only 22 is upon the excavating or filling up the ponds. And 21 in respect of cutting the trees and excavating the government road.
I am not in 21, item number 21, but I am in item number 22.
But he has filed a CAN application in 21.
Yes, my lord. In 21.
And who will appear for the state in 21?
No, I don't know. I'll have to find out. Same plot of land niye? Hey.
Same plot of land.
ওটাই ইস্যুটা কি?
ওটাই ইস্যু হচ্ছে মাইনিং হচ্ছে গভর্নমেন্ট রোডে আর এটা হচ্ছে যে ওই মাইনিং করতে গিয়ে পুকুর ভরাট করছে।
Probably they have not noted it today. It was supposed to come sometime in April 24. It has come up only now.
Main application is supposed to come on every Thursday, we have mentioned.
Notice.
Sivangi Third, on behalf of the
Keithan and Company Association. Keithan and Company appears for?
Appears for the respondent. Private respondent 11. 11 and 12.
Then we have to get somebody for the state. You can get it.
I'll have to take the instruction, but until unless I have the copy of the.
Because earlier the learned Assistant Additional Advocate General appeared.
Oh. In item number 21.
Both.
Okay.
You just see this appearance.
Malad.
Then let it come next week. In the meantime, you inform them.
Kindly let it retain its position.
Yes. List next week.
Application
to
like
to enable the learned advocates appearing for the state and the other respondents to appear. This next week under the same caption.
Only urgency is, my lord, because they are continuing.
Continuing to
waiting.
There is no urgency. I'm ready with the next matter. There is no existence of pond.
Yeah, but this scan is we have filed because there is urgency, because they have gotten permission, which is illegal. I will show that, my lord.
I'll show that its mining operation has been running there since ages.
And my lord,
There is no existence of pond.
permission granted, my lord, in the year of 2024 after filing.
It's a case of a wrong recording in the land reforms record. That's it. Nothing more than that.
Next.
Serial number 23.
In 23, my lord, I appear for the appellant applicant. This is my application taking affidavit solution. I have solved, my lord. দুটো আছে তো affidavit সার্ভিসটা affidavit সার্ভিস না এটা বাদ my lord, your lordship's order dated 24th April 2024 is under review.
Deficit court fee paid.
In review, my lord. Then, my lord, probably my
Because stamp reporter says there is a deficit court fee. What is the review you want, sir?
Review is this, my lord, that in the writ petition there was an alternative prayer by the senior citizen widow. Her husband, my lord, because of her old age, my lord, requested and made a prayer to the DM, district magistrate, for, my lord, transferring his stamp vending business in Srirampur court to his son. That was done. That was done. But that was the only property that the family could survive. Please let me, sir. Please let me complete. That was an alternative prayer. If your lordship may kindly turn to, my lord, in my writ petition, that is annexure P1 to CAN 1. CAN 1. CAN 1. My lord, page 7. Page 7.
Yes.
Starts, my lord. If your lordship kindly turn to inner page 18 of the petition. 18 of the petition. Read petition.
There is no page 18 in CAN 1.
Hello?
There is no page 18 in CAN 1.
My lord, running page 24. Running page 24. Read
Last
petition.
page is page 11 of CAN 1.
Petitioner's contention is
All
that fast the appeal behind his back. He was not appear.
Alternative, please. Please let me complete. I have on a point of law. I am a point of law. Please let me complete, sir. Please let me complete. This is my case. Alternatively, to pass an order directing the respondent authorities to transfer or issue fresh stamp vending license in favor of the petitioner for carrying out such. If you continuously interrupt in my submission, then
No, which this is item number 23.
23.
He has been placing the writ application here.
Yes, I was placing the writ petition in CAN 1 filed in the MAT.
Nothing in the.
It is not here. MAT file is not here.
Oh, I see. Then I'm sorry, my lord. But in my writ petition, my lord, I made a prayer, alternative prayer. I did not, my lord, approach the tribunal. So therefore, the question of pecuniary jurisdiction of tribunal did not or could not arise. Because I had a prayer for 30,000 maintenance, but the pecuniary jurisdiction is 10,000. So, my lord, it could not be. That is why the writ petition was dismissed with the idea that I may approach the other civil code or criminal code. But that question could not arise because, my lord, I did not approach the tribunal. I made a prayer to the district magistrate for a direction so that the stamp vending business license could be transferred to me so that I could survive. That, my lord, prayer was not considered. Section 23(1), my lord,
speaks of clearly that if the senior citizen is neglected to be maintained by the son or other relations, then the transfer by way of gift or otherwise, his property subject to the condition that the transferee shall provide the basic amenities and basic physical needs to the transferee, or such transferee refuse to fail provide such amenities, physical needs. The state transfer of property shall be deemed to have been made by fraud or coercion or undue influence, and shall, at the option of the transferor, be declared void. In that regard, one judgment has been passed by in 22 by the Honorable Supreme Court. I have not SCC online, it is 1655 page.
No,
That is very important.
No. Very recently also.
Yes.
Another judgment
Uploaded,
was-
yes. So if your lordship kindly allows the review application, allow me to place the appeal kindly, my lord, so that the helpless lady senior citizen can survive.
No,
Because-
what was the prayer and the writ petition? You show the prayer and the writ
My lord,
petition.
my lord.
Copy, produce the copy.
I have got one copy, my lord, kindly allow. Kindly for. Next, my lord. Alternate prayer.
Now, initially, the mother granted consent to transfer the license in favor of the son.
What?
Yes.
May I?
My lord, P1 and
The,
P2.
the stamped the lady has three sons, my lord. One of the son applied before the my lord for the stamp pending authority for compassionate appointment, that has been rejected. But the son, respondent number 5, another son, he independently applied before the my lord. Your lordship kindly go through the order of the writ application. The writ application, it has been categorically stated in the order, my lord, itself, my lord.
My husband applied for transferring the
It is submitted
license.
by the learned, para 3, it is submitted by the learned counsel for the private respondent that the stamp pending license was duly given to the private respondent on his individual application. And my lord, para 5, lordship got it. And para 7. It's a perfect order.
If your lordship kindly allow me to reply to my learned friend's submission, factual submission. Petition
See, if the second son had obtained a license in his individual capacity, not as a legal heir of the father, then your client cannot ask him to give accounts.
If you kindly turn to annexure P1 and P2 to my writ petition, kindly. Kindly. P1 and P2 to my writ petition. My husband has made a prayer. P1.
But that application was dismissed.
That application has been dismissed.
On the basis of that application, P1 and P2, on the basis of that application, the stamp pending license was transferred in the name of the private respondent, that is the
Not on compassion.
respondent number 5. Kindly see.
The son applied, moved the writ application in this court itself. And my lord, that has also been rejected.
No, that is not correct.
No, can you produce some record to show that the license granted to the son was not on compassionate ground, but by individual application?
Grateful,
My lord,
grateful, Your Lordship. I've got
my lord, I am not with the instruction today, my lord. I am what I am submitting from the order itself, my lord. It has been stated in the order.
But there is no record produced.
And my lord, he should serve copy upon the private respondent also. He can, my lord, produce the things, my lord. It is his
No,
submission
I
recorded in
I am referring to from the annexure to my writ petition.
No. First of all, in the stay application, the required annexures are not there
Yes, yes.
in this review.
Yes.
So you please annex it.
Yes.
Or we can do one thing, call the MAT file.
Yes, writ petition could be.
And in the MAT as well as the writ petition.
Yes.
And you serve notice on the private respondent.
Yes.
Let notice be served on the private respondent number
5. 5. Number 5. Only,
who is the sixth respondent?
well, I'm telling you. 5.
6 is Ashim Kumar Rakshit, another brother. My another son.
All right, you serve on both of them.
Yes, my lord.
Let notice be served on the respondents number 5 and 6. Who appeared for them in the writ petition?
Yes.
respondent number 5, my lord.
And also inform and also serve copies of the review application along with all annexures on Mr. Sopan Kumar Nandi and Mr. Dabajyoti Ghosh, who appeared for the respondent number 5 in the writ petition.
Yes.
Since since the annexures in Can 1 of 2024 does not contain all the relevant papers, the department is directed to put up the file in a MAT 2364 of 2023 along with this review application.
Along with the writ petition, my lord, writ petition file.
And also the
Connected.
file relating to WPA 21565 of 2020.
Yes. That is other.
The learned advocate for the appellant review applicant is directed to remove the defects pointed
Yes,
out by
deficit, must.
registry within a week from date.
Yes, my lord. Deficit court fee, yes. I'm grateful to your lordship. My lord,
He will tell the date.
Next. Number 24.
18 February. Writ petition copy দিয়ে দিন। Writ petition copy দিন।
My lord, challenges an order passed by the West Bengal Taxation Tribunal. My lord, there was a direction for exchange of affidavits. My lord, state has filed their affidavits. My lord,
We are filing our affidavits. It's your lordship. Reply দিয়েছি।
my lord, we also wish to bring on record a reply to their affidavit. And my lord, there are certain illegible documents which forms a part of the application, my lord. So we seek your lordship's leave to file a supplementary affidavit. These would be the typed copies. And then, my lord, there's no scope really of any interim orders. Your lordship can fix any day convenient to your lordship. The matter needs to be heard.
In February, we'll fix it.
Remission of sales tax. Enhancement, they have refused the enhancement. So that is the scope of challenge here.
Affidavit in opposition has been filed by the respondents, to which a reply has been filed by the petitioner. Same are taken on record. The supplementary affidavit filed by the writ petitioner enclosing copies of the illegible documents annexed to the writ petition is also taken on record.
Supplementary
As the pleadings are complete, the appeal has to be, the writ petition has to be heard. Let the matter appear in the monthly list of February.
Serial number 25.
There is, sorry, the order, there appears to be, this is a server error. This is the order in this particular FMA number. The order is going down of another matter.
So, but this is what has gone down, but if your lordship will see the number of the matter is the same, possibly it's a, if this could be correct.
This is
16 টা কবে কাজ ছিল? On that day, this was item number 16. So it got replaced with the other matter, next matter. So I'm sure, my lord, that they will do the needful. Right.
Oh, the cost title is also.
Yes, yes. Cost title change. In fact, the constitution of the bench has also changed.
The constitution bench.
তা বললি কেন সেই কথাটা তাহলে? No, it's the same.
In the order dated 24/9/2024, 24/9/2024, the case number, the CAN numbers, and the cost title has been wrongly shown. This defect be rectified and the correct cost title be shown and the correct case number. The order shall form part of the order dated 24/9/20.
Even the appearance, all is wrong. But the entire,
As well as
basically
the
it got
appearance-
substituted by item number 16. Very good.
Official final.
Serial number 25. Lord, I appear for the appellant. There was a direction for filing of the paper book, my lord. By Friday, we'll file the paper book because the respondent numbers, read petition respondent numbers 2 and 6. We are yet to file them because my learned senior friend appears for the other respondent, read
1,
petition
3,
respondent.
4, 5, 7.
My lord. So we are,
Who will appear for 2 and 6?
Lord, we do not know, my lord. We will be sending them directly by post, my lord, and we are just send it to the department, the paper book. So after this service is effected, my lord, the department will accept the paper book. That is what I am told. And we have already served today. We have served a copy of the paper book to my concern.
2 and 6 are private respondents.
They were private writ petitioners. All the writ petitioners joined hands together. But my learned senior friend is not appearing for.
Actually, we represented them in the tribunal, but my learned advocate on record, Lord, he has not received the wakalatnama from
Why
these
can't
persons.
you get the wakalat?
They have not. I believe, Lord, he had written a letter to these persons, but my lord, still the wakalatnama hasn't.
If they've been served, they don't appear, forget.
That is one. So we will be filing a paper book, my lord, by Friday, no?
Department.
In the department by Friday, my lord.
Rectified spirit. That the issue is whether state can impose a fee, which is not the highest rate of duty charge for not potable alcohol in respect of rectified spirit, not which is imported not for the purpose of making potable alcohol. Lord, we are a manufacturer. We get the rectified spirit, and Lord, we sell the spirit to Lord the furniture polishers, Lord, in the rectified spirit stage. Lord, we are not into potable liquor at all. So, Lord, this is the issue that was raised, and Lord, it has been held that the state doesn't have the power in view of Section 86 read with Rule 38 of the Consolidated Rules. The state doesn't have power to levy a fee on rectified spirit, wastage of rectified spirit. Wastage of rectified spirit. This is actually the wastage, not the rectified spirit, the wastage of rectified spirit.
That is rectified spirit is sold as it or any denaturant is added and sold.
It is sold as denatured spirit.
Ah.
Sold as denatured, not as denatured. Blood, these are sold blood as rectified spirit without blood with some purification effect which takes effect. Then blood we sell it to the consumers who are blood also who utilizes it as industrial alcohol. There is no question of any conversion into a potable liquor. The wastage that happens blood in the process, that is what they are charging blood at the highest rate of the excise duty.
But whether that synthetic chemicals judgment.
Synthetic has been blood watered down now by reason of this constitution bench judgment which has been delivered in 2024.
No state.
In other states,
that was the argument, Lord. The basis of the argument was synthetics there and Modi distillery following the synthetics that was there. But Lord, now your Lordship will have to consider, Lord, the
decision.
Where, Lord, my reading of the judgment is the Supreme Court hasn't said that state can levy any fee or tax on that.
দেখাবো যখন পড়বো তাকে ওই যাবে কনফারেন্সে বলছে ঠিক আছে
So there was a differing opinion. It went to the third member.
No. 2:1. 2:1.
2:1.
Because Lord, the constitution points, when the constitution points are involved, normally tribunal constitutes Lord with 3 members. I think Mr. Bachawat, who's the administrative member, he differed.
One judicial member and one technical member agreed. Saying that
chairman and the technical member, the judicial member, yes, your Lordship is right.
Vinod Kumar Srivatsa was judicial member.
Vinod Kumar Srivatsa was the, yes.
And he agreed with
the chairman. The chairman. Judicial member and the chairman, they agreed. The judicial member and the chairman agreed. They concurred. The technical member disagreed. In fact, your Lordships will find the dissenting judgment coming first. That is at page 98. অন্য দুজনের
পেপার বুক এখন 98 হয়ে গেছে
in fact we just got the paper book. I am not
no problem. We're just seeing what is the issue.
I'll show your Lordship. The chairman's judgment starts at page 127.
পেজ 150 ওখানে এগ্রি করছে হ্যাঁ ঠিক আছে আরো সব চারটে ডিপার্টমেন্টে ফাইল করছে কি পেপার সাদা কপি ডিপার্টমেন্টে ফাইল কেন ও তাতে পেপার দিচ্ছে এটা করতে হয় নাকি আমরা তো কোর্টেই দিতাম মধ্যে করতো আমাকে রাইট মানুষ
Even the dissenting member, your lordship permits, at page 124, paragraph 21 onwards, your lordship will find even the dissenting member, on a principle of quid pro quo, directed the state respondents to justify their claim. That is your lordship will.
Because a levy of fee has to have a reasonable
Nexus,
nexus.
reasonable nexus. Quid pro quo.
This is wastage fee.
Wastage.
And it is not your case that the spirit was diverted.
It is not regulatory. It is, we said it is regulatory. No, that case was not made out that we are diverting or anything of that sort. But they say that this is necessary for us to protect this wastage.
For diverting it for other purpose. But I have just received this paper book.
But there are a lot of states which have banned sale of rectified spirit to industries. And they have said that we will be only selling denatured spirit. And the concerned industry can specify what is the denaturant to be added, so that it does not have any adverse reaction in their manufacturing process. Because the large scale diversion. Here we have got porous borders also.
The porous borders, Lord, does not help this kind of industries because, Lord, here there is.
They are all homeopathy practitioners.
No.
I mean, homeopathic drugs they manufacture.
Doctors are there. Dr. SC.
Homeo Research Laboratory, Super Spirit Warehouse, Arco Spirit Warehouse.
There are doctors, my lord.
So they are all not relatable to
homeopathic medicine.
Lord, the
পোর্শনটা কি মেডিসিন হয়ে যায় নোটটা কোথায়
Supreme Court judgment and
compilation করে দিতে হবে আসলে এই মামলায় compilation
Lord, perhaps, Lord, your lordship is right. There are Lord, two sets. One is the rectified spirit, which is sold for manufacture of pharmaceutical or medicinal purpose. That's one story. And the other is the denatured spirit, which is produced, Lord, from the rectified spirit, that is sold for industrial purpose. These are the two different purposes for which, Lord, the wastage, in both cases, it's the wastage.
But we are not concerned about that. It's only the wastage fee.
Yes,
Which is
that is the
Competence of
challenge.
the state to levy such fee.
Yes, that's
Have you been able to demonstrate that there is some nexus or for some service rendered or something like that? It's not a tax.
and it is regulatory, my lord. We'll demonstrate before your lordship that is because to my lord, stop the diversion, it is regulatory in nature. And whether we have that my lord, power, my lord, it has now been settled, my lord. My learned senior friend says otherwise, that the judgment of the constitutional bench. But now it has been settled, my
the
lord. that we-
regulatory power. I am not, Lord, I can't, Lord, dispute the regulatory power.
and that is our
I am only questioning, Lord, his power to charge the wastage fee at the highest rate of the duty that they charge for, Lord, potable liquor.
No, that is only a measure. Let us say 8%, 10%, 20%. You can draw an analogy saying that this is for imposed as a fee for potable liquor. So probably they have adopted that figure. This,
They are
according to them, this fee is levied so that it is no longer profitable for the person to divert.
Lord, what their analogy is,
It's a big market, sir.
Lord, it may be a big market, Lord. I don't dispute that. But the question is, Lord, whether everybody is not involved in such a trade. That's the point. And Lord, their analogy is that this is the loss.
80% are involved.
Lord, they say this is the loss that the state is suffering. Lord, I don't understand there. They are saying this is the loss that the state is suffering, because if this
would have been
was
sold.
utilized for potable purpose, then we would have earned this much of money. That is the wrong analogy. That can't be the basis of regulation.
For almost 6 years, I had appeared for about 12 such companies. So it will be an uphill task. Let us see.
Lord, uphill task for me.
My lord, I have just received the copy of that paper book, my lord. I'm filing those paper books.
Paper book taken on record. Give a date in April or so. April, May, or after your vacation.
My lord,
But this definitely, Lord, will have some attractive arguments. This much I can tell you,
we are-
Lordship, because there was one view, now there is another view. There is a
And
change of
secondly, you can also see some of the Kerala High Court judgments, because there are a lot of Ayurvedic practitioners. And there is nothing, no Ayurveda inside that court. 90% purity.
90%.
90% purity. And those Ayurveda Ratna, this Ratna, Homeo Ratna, all Ratna all gone. Fellows who claim to be descendants are all into this trade. So the Kerala Excise Act was amended. And unless you have a manufacturing facility, the question of supply of rectified spirit doesn't arise. They will say, we are in the one small room in my house, I will mix all five ingredients. This will cure cough, this will cure fever, this will cure your knee pain.
But there's no regulation in that way. I mean, the licenses and
here there is nothing. I don't know whether the homeo practitioners here have to possess license.
No, of course they will. Not under the Medicinal and Toilet Preparations Act. In so far as the Excise Commissioner is concerned, he is also, Lord, appointed as the authority under that act. So, for getting the alcohol, we'll need their permission.
In fact, while transporting also there are rules.
Yes, yes. Transport fee is also charged on that.
and time has to be maintained. And there will be one excise officer who will be stationed in the plant, where manufacturing plant. And the rectified spirit has to be offloaded into that particular plant, I mean tank.
Yes,
And purity, quantity will be checked.
absolutely. And here in West Bengal, Lord, we don't have, Lord, rectified spirits manufactured here. So we have to get it from other states, Odisha, neighboring states.
That's where the problem is. Anyway.
স্যার আমরা ভুল পজিশনে দাঁড়িয়ে আছি
ও
সরি হ্যাঁ না স্যার ঠিক আছে ওল্ড হ্যাবিটস ডাই হার্ড আমি সবসময় রেসপন্ডেড হয়ে দেখিও না
আমি দেখলাম একটু এদিকে দাঁড়িয়ে আছে so আমি I took this side.
আমি ভুল
Never
করলাম
consider.
আমিও ভুল করলাম পড়তে হবে তো ভালো করে স্যার এত টেকনিক্যাল কথা হলো আমি আনটেকনিক্যাল হয়ে গেলাম ব্যাপারটা কিচ্ছু
Yes, this is restore it.
মাথা দিয়ে সব কথা দরকার আছে ওটা কিন্তু বলছে আমাদের কোনো উত্তর নেই আমার সেটা ছিল জিএসটি আপডেট থাকে অফিসের অনেক ওকে ওটা কিন্তু আমি বললাম রিফান্ড
No correction.
তুমি এটা ফিক্স করতে পারো না আমি করতে পারি
But he didn't appear on that day.
Bureau of Investigation ছিল
Okay, then okay, we'll come back.
দিয়ে দেবে দেখেন
Serial number 26.
In this matter, my lord, I have also concluded my argument. My learned friend also concluded his arguments. Only thing which was left from my learned friend's side was, my lord, the distinction of the judgment cited by me.
This is that.
That classification matter, my lord, whether my item is an item of plastics or textile.
My lord, in this matter, my lord, I supposed to give reply, my lord. Today, my lord, I am not in a position, my lord, to attend you, lord.
My lord, he submitted his arguments. Only thing is that
kindly,
he needs to distinguish my judgments.
My lord, kindly fix up. My lord, kindly text up, my lord. Any other day, my lord.
But it was heard prior to, my lord, vacation. What I'm requesting is, my lord, if, my lord, we can submit our written submission and cover whatever we have to say, my lord.
And notes is there.
But I need 1 day, my lord. Kindly, my lord, accommodate, my lord. Kindly give some accommodation, my lord.
No. You want to make oral submissions or you want to
My
give
lord,
a
I
written?
want to make oral submission, my lord. Today I am not in a position, my lord. I couldn't attend the court today, my lord. Some difficulties, my lord. I am not well, in fact. My lord, kindly, if your lordship, my lord, 11th, if it is possible, my lord, I think that will be better, my
No,
lord.
no. What we'll do is we'll just say not today, so that it
Oh,
will remain in the list.
My lord, my lord, my lord, my lord.
Serial number 27.
Now the writ petition is still pending, challenging the validity of Rule 61.
Well, your lordship directed the affidavit to be filed before your lordship. So that has been done.
Okay.
So, my lord, this matter needs to be heard by your lordship only.
That is, we have to hear the validity of the rule as well as.
My lord, I think, my lord, even without going into the issue of the validity, my lord, the issue which is there, my lord, it is covered by your lordship judgment. One of the judgment. My lord, the short issue is, my lord.
Yes.
The short issue is that, my lord, in the first year of the GST, my lord, there was a short return to be filed. Initially, the GSTR 3B return which was introduced, it was said that since GSTR 1, 2, and 3, these 3 returns were supposed to be filed. GSTR 1 for sales, GSTR 2 for purchase, and GSTR 3 was supposed to be the final return, incorporating 1 and 2. So, my lord, in the first year, it was notified from time to time that GSTR 3 will be notified. And they kept issuing notification till 2020. And they say, and in Rule 61, which mandated filing of this return either in GSTR 1, 2, 3 or 3B, Rule 61, Sub-Rule 6 stated that if there is any error or omission in filing of the GSTR 3B, either with respect to of the taking of the credit or with respect to the declaration of my output liability, I can rectify that in GSTR 3 return, the final return, after 3B, which was supposed to be filed. In my case, what happened is that by the time the 2019, the due date of filing of the annual return came, that was the first opportunity for me to rectify my errors with respect to output as well as input liability, because I was in the hope that GSTR 3 final return will be notified and I will be able to finally rectify my errors. So, and there was a press release also which was notified. My lord, the press release,
page 113.
Page 113, which said that if you have failed to, if you have committed any error in the filing of the return, then you can rectify that through GSTR 9 return. So, my lord, I rectified my errors in the output liability, and with respect to my input tax credit, my lord, what had happened is that I am providing parking services to the railways. Railways, my lord, was issuing a ticket, just like the paper ticket which we get from the platform sort of a ticket. That ticket they were issuing with indicating the total amount, my lord, they have paid to me without bifurcating between the GST and the amount which I am supposed to take as a credit. So, till the filing of my monthly return, I took the credit as per the returns filed by, because they did not disclose all the liability. There was some pendency from their side. So I took the credit which whatever was declared by them till filing of my monthly returns. And when I filed my final GST annual return, then I rectified my error with respect to my input tax credit as well as my output tax credit. With respect to my output tax credit, the officer does not dispute. He has accepted whatever error I have committed and I have discharged all my liability. With respect to input tax credit, he says that you are not entitled to this credit because you have passed the date of section 16(4). My lord, that 16(4) also subsequently, my lord, my lord, the department issued has come up with the amnesty scheme, and for those 4 years, if I have filed my returns, then they say that if it is filed within the 2022, then you are entitled to take credit. My lord, in my case, there is no delay in filing of the return. The only problem is that I have taken credit through GSTR 9. GSTR 3 was never notified. There was no option to revise the GSTR 3B return. There was no mechanism because the department instead was contemplating that whatever error in omission is there, it can be rectified through GSTR 3. So the only reason I have challenged the Rule 61 Sub-Rule 6 is, which was omitted. And my submission is that the GST Council, which is supposed to recommend any changes in the law, only recommended, my lord, amendment in Rule 61 Sub-Rule 5. It did not, my lord, amend, my lord, it did not state that Rule 61(6) has to be omitted altogether. But it was done. So, my lord, that is the reason I have challenged. But, my lord, I am covered by your lordship one judgment, my lord.
Now, before that, can you show us the adjudication order?
Yes, my lord. Adjudication order, my lord, is on page 183, my lord. Page 183 onwards, but the relevant part is on page, my lord, 187 and 188. 187, 189, in fact, the last paragraph is the observation of the officer, my lord. Last paragraph. Page 189. Shall I read out, my lord? After examining the document submitted by the RTP, following observation is drawn. Press release dated 3rd July by the GST department, it is not applicable in this case. Statement of reconciliation of liabilities. The RTP has submitted same reconciliation statement which he has already submitted in his reply in ASMT 111, which is found not acceptable for above mentioned ground. Order of Kerala High Court, the judgment cited by the RTP's case is specific, therefore cannot be taken into cognizance for the purpose of this case. Documents relating to payment of license fee along with GST to Eastern Railways, it is not denied at any stage of the proceeding. The RTP has also cited Circular 183 at so and so. Circular 183 deals with the discrepancies between the amount of ITC availed by the RTP in his returns in Form 3B and amount of ITC available in Form 2A. But in this case, RTP has not availed ITC in Form 3B to discharge his output liabilities which he has declared in GSTR 99C. So it is a case of discrepancy between outward liabilities declared in GSTR 99C and outward liabilities discharged through GSTR 3B. Hence, circular number so and so is not applicable here. RTP, knowing the fact that undersigned have to comply the order of Honorable Kolkata High Court and to pass order within 6 weeks of the receipt of the representation made by, has furnished a reply in Form DRC 06 on 5/6/23 requesting for another hearing date. But it is not possible as per order of Honorable Calcutta. Therefore, undersigned has no option but to pass summary order under section 79 as per order of Honorable Kolkata High Court, and DRC 07 has been uploaded electronically, specifying therein the amount of interest, tax and penalty. But as per page 188, my lord, may I also read out the reconciliation and the so the dispute, my lord, will come out. Shall I, my lord, refer to page 188?
Yes, sir, I am going through it. But he says that RTP has claimed that he has paid so and so voluntarily as per GSTR 9.
Yes, correct.
But failed to furnish any document in support of his claim. Moreover, there is no reflection of this payment in the GST BO portal.
But those challans, my lord, I have enclosed, my lord, with the petition, my lord. If your lordship sees, my lord, the calculation, my lord.
No, on that particular day, 3B was not notified. I'm sorry, 3 was not notified.
3 was not notified.
So only opportunity you had is to rectify it in 9 and 9C.
Correct. That I did.
But he says that you have not claimed it in 3B.
That is that statement what he is making is correct. But what I am submitting, my lord, is that on that particular date, since I had no opportunity to revise the return, there was no opportunity to revise 3B itself. The only last opportunity as per the press release also is to correct all the errors through GSTR 9, which I did. And I was hoping that GSTR 3 will be notified sooner or later and I will rectify all the errors through that final return. At that point of time, GSTR 3 was supposed to be the final return. My lord, may I show one of the notification, my lord, which says, my lord, the extension of filing of the return in GSTR 2 and 3.
No.
Well, your lordship has dealt with this issue, that it is a revenue lateral situation. The GSTR 9 filing cannot be an empty formality. it has some purpose. It is not that if there is some error and omission on my part, then I cannot do anything through GSTR 9. And when there is a judgment of the Honorable Madras High Court to this effect, and your Lordship order is also there, but kindly allow me to refer to these two judgments only. One of Madras High Court. There are other judgments also, but I will not refer to all the judgments. But kindly refer to page 56, my lord. Page 56, your judgment starts, my lord. But page 57, I'm reading from paragraph 3, my lord, where the issue has been framed. The sought issue which falls for consideration is whether the annual return filed by the appellant in GSTR 9 for the financial year 17-18 can altogether be ignored. At the earliest point of time, the appellant by letter dated so-and-so addressed to the officer concerned gave a clarification stating that they have filed GSTR 3B for the period so-and-so, which does not include both input and output sales, and they have filed GSTR 1 for the month of October 17, which does not include sales, but have filed GSTR 1 for November 17 to March 18, which includes sales at the rate of 5% and sales at the rate of sales specified amount. The appellant submitted a statement of sales and specific sales with input, output, and carried forward. Subsequently, another communication was sent bringing to the notice of the department certain information as contained in 9. The appellant stated that during preparation of data for GSTR 9, it was noticed by him that they have inadvertently missed certain output GST liability on account of compensation sales from GSTR 3B return for relevant financial year, and have also missed equivalent amount of input tax credit of sales for such supplies. It was further stated that while filing GSTR 9, they have corrected the error by showing the exact amount of compensation sales payable by them during the said period, as could be seen from table 4A of GSTR 9. The appellant further stated that they have shown the actual amount of ITC on compensation in GSTR 9 filed by them, as can be seen from table 6B of the said GSTR 9. Further, it was stated that input tax credit is also matching with the auto-populated figures of GSTR 2A. The appellant stated that the error was unintentional as the GST was a new at the relevant time and is a small SAC, and there was no revenue loss to the government as the entire exercise was revenue neutral, and also there was no gain to the appellant by showing incorrect figures in their return as they have sufficient balance of input tax credit for the same. Therefore, it was submitted that the error was not unintentional. It was without any ulterior motive and mensory and intent to evade tax. Therefore, the authority was requested to take into consideration the same. However, the pre-so-cause notice intimation, which was given on so-and-so date, the authority was not inclined to do so, and as requested by the appellant on the ground that the GSTR 3B was not rectified within the time permitted. Once again, the appellant submitted representation, but however, the adjudicating authority in the order dated so-and-so maintained the same state. In our considered view, two aspects have appealed to us to send back the matter to the adjudicating authority. First is with regard to the effect of GSTR 9. This being an annual return filed with the extended period of limitation up to 7th February 2020 on account of various notifications issued by the government due to COVID pandemic. Therefore, if the GSTR 9, which was filed within time, is not considered, the SSC's right would be greatly prejudiced. The second aspect which have persuaded us is the contention of the SSC that the entire matter is revenue neutral. Thus, considering the peculiar fact and circumstance of the case, making it clear that this order should not be treated as a precedent, we are inclined to remand the matter back to the adjudicating authority, the Assistant Commissioner, to consider the submission made by the SSC and afford an opportunity of personal hearing, examine the annual return filed in 9, and proceed to take a fresh decision on merit in accordance with law.
Then what happened in this case?
In this case, what exactly happened, this is not my matter, so I cannot comment on that. But I wish to refer to one judgment of Honorable Madras High Court also. But kindly refer to page 3, my lord. Page 3, my lord, is the judgment starts, my lord. I refer to, my lord, page 4, my lord, paragraph 2. The petitioner carries on trade in electronic products and hardware by asserting that nil returns were erroneously and inadvertently found in GSTR 3B return. The petitioner states that he is eligible for ITC in each of the above mentioned assessment periods and that this is duly reflected in GSTR 2A return. Consequently, the petitioner states that the GSTR 9 annual returns were filed duly reflecting the ITC claim of the petitioner. By rejecting such claim, it is stated that the orders impugned herein were issued. Now, my lord, I will kindly refer to paragraph 6. When the registered person asserts that he is eligible for ITC by referring to GSTR 2A and GSTR 9 return, the assessing officer should examine whether the ITC claim is valid by examining all relevant documents, including by calling upon the registered person to provide such document. In this case, it appears that the claim was rejected entirely on the ground that the GSTR 3B return did not reflect the ITC claim. Therefore, the interference is unwarranted with the orders impugned herein. For reasons set out above, the orders impugned herein are quashed and these matters are remanded for reconsideration. The petitioner is permitted to place all documents pertaining to its ITC claim for assessing officer within a maximum period of 2 weeks from the date of the receipt of copy of this order. Upon receipt thereof, the respondent is directed to provide a reasonable opportunity to the petitioner, so and so. But now, my lord, kindly allow me to refer to, my lord, the state of GSTR 3B and GSTR 3 return, which was supposed to be extended, my lord. Just, my lord, kindly refer to page 191, my lord. Well, this is minutes of 18th GST Council meeting held on 30th June 2017. But kindly refer to page 194. My lord, kindly see serial number 3, my lord, in the table. Serial number 3 in the table, my lord. Return Form GSTR 7A 45.3, 45.4, Rule 61.5. This Rule 61.5 is amended. Form GSTR 3B addition. Shorter return for first 2 months of rollout. So that was the objective, my lord, that the shorter return for first 2 months of the rollout. Then, my lord, kindly refer to page 195, my lord. The time limit for furnishing the details or return, as the case may be, under subsection 2 of section 38 and subsection 1 of section 39 of the Act for the months of July 17 to July 19 shall be subsequently notified in the official gazette. So return to be furnished in 38 and 39 was to be notified in the official gazette. Now, what was the return to be filed in section 39(1), my lord? That is prescribed in Rule 61, my lord. Kindly refer to, my lord, page 203. At is existed at that point of time, my lord. 203. But sub rule 1. Every registered person other than a person referred to in section 14 of the Integrated Goods and Services Act 2017 or an input service distributor or a non-resident taxable person or a person paying tax under so and so shall furnish a return specified under subsection 1 of 39 in form GSTR 3 electronically through common portal or through a facilitation center. So 39(1) return was GSTR 3. Then, my lord, kindly refer to 4, my lord. Under what circumstance 3B is to be filed? A registered person claiming refund of any balance in the electronic cash ledger in accordance with the provision of subsection 6 of section 49 may claim such refund in part B. Sorry, kindly refer to subsection 5, my lord. Subsection 5, where the time limit for furnishing of details in form GSTR 1 under section 37 and in form GSTR 2 under 38 has been extended and the circumstances so warrant, the commissioner may by notification specify the manner and conditions subject to which the return be furnished in form 3B electronically through the common portal, either directly or through a facilitation center notified by the commissioner. Now kindly refer to 6. This is most crucial for me. Where a return in Form 3B has been furnished after the due date for furnishing of details in Form 2, Part A of the return in Form 3 shall be electronically generated on the basis of information furnished through Form GSTR 1, Form GSTR 2, and based on other liabilities of the preceding tax period. And Part B of the said return shall be electronically generated on the basis of return in Form 3B furnished in respect of tax period. The registered person shall modify Part B of the return in Form 3 based on the discrepancies, if any, between the return in Form 3B and return in Form 3 and discharge his tax liabilities and other liabilities, if any. Where the amount of input tax credit in Form 3 exceeds the amount of input tax credit in terms of Form 3B, the additional amount shall be credited to the electronic credit ledger of the registered person. So this was the situation, my lord. Now, my lord, this was amended, my lord, by
on what date 3 was notified?
Yes, my lord.
On what date GST
3 was, my lord, never notified. My lord, kindly refer to the last such notification, page 198.
shall be subsequently notified.
The time limit, my lord, for furnishing of the details or return as the case may be under section 2 of the 38, which is GSTR 2, shall be subsequently notified. Prior to this, my lord, there is this notification. Kindly, sorry, for 9, this is the last return, page 196, my lord. The time limit for furnishing of the details of the return, as the case may be under section 2 of 38 and subsection 1 of 39, for the month of July 19 to September 19 shall be subsequently notified. Prior to that, my lord, July 70 to July 90 is page 195, the notification on page 195. July 70 to June 19.
What is the period?
Then
in this case, what is the period?
17, 18, my lord. Then, my lord, kindly refer to page, my lord, 209, my lord. The amendment in Rule 61. The GST Council decision, my lord. 209. This is the 30th GST Council meeting, my lord. But kindly refer to page 211. 211, my lord. Paragraph 28. Introducing this item, the co-convener of the law committee stated that the Honorable High Court of Gujarat had passed an order on 24/6/19 in the case of AAP in India versus Union of India, stating that the form GSTR 3B was not a return which led to further challenges such as legality of interest payable, as Form 3B was not considered as a valid return etc. Therefore, the law committee proposed an amendment to Subrule 5 of Rule 61 to say explicitly that Form GSTR 3B is a return under subsection 1 of the 39 of the Act. He added that the proposed amendment was to be carried out retrospectively from 1/1/17, so that the legality of tax liability or interest liability could not be challenged on this account. It was also decided to challenge the order of the Honorable High Court of Gujarat. For agenda item 7, Roman 7, the council recommended to amend Subrule 5 of Rule 61 of the CGST rule to prescribe from GSTR 3B as a return under section 39 of the CGST Act retrospectively with effect from 1/7/17 as provided in the agenda note. The council also approved the suitable notification shall be issued after due vetting by the Union Ministry of Law, and perimeter changes shall also be made in the AGST rule. Now, my lord, kindly refer to amendment in the rule, my lord. Through, my lord, notification 14/2019, page 199, my lord, the notification. Page 199, serial number 4, my lord. in the said rules, in Rule 61, shall I read out? Paragraph, my lord, serial number 4, my lord. Serial number 4 of this notification. In the said rules in Rule 61, for sub-rule 5, the following sub-rule shall be substituted with effect from 1st July 17, namely, sub-rule 5 has been amended, where the time limit for furnishing the detail in form GSTR 1 under section 37 or in form GSTR 2 under section 38 has been extended. The return is specified in subsection 1 of 39 shall in such manner and subject to such condition as the Commissioner may by notification specify be furnished in form GSTR 3B electronically through the common portal, either directly or through a facilitation center notified by Commissioner. Provided that a return in form GSTR 3B is required to be furnished by a person referred to in sub-rule 1, then such person shall not be required to furnish the return in GSTR 3. Then, my lord, sub-rule 6 shall be omitted with effect from 1st July. So, this sub-rule 6, my lord, as Lordship, I have referred to that GST Council meeting. There is no, my lord, recommendation for omission of this rule. Only recommendation is with respect to amendment of the rule, and the objective being that since the Gujarat High Court said that GSTR 3B is not a return under section 39, because sub-rule 1 of Rule 61 stated that GSTR 3 is the return under section 39. So that was creating trouble. So all that the GST Council recommended is that GSTR 3B be notified as a the return under section 39. That is all. But it is not that the rules, sub-rule 6 is very vital for particularly the taxpayer, because as far as output tax liability is concerned, the department does not dispute. As much as I pay, they will accept with interest and penalty everything. But my right to claim input tax credit, which was also part of rule sub-rule 6, that whether you make error in the output tax liability or input tax liability, you have an opportunity to rectify through this GSTR 3 return, which has been taken away retrospectively, my lord. So, my lord, this retrospective part is...
In your case, 3 was never notified.
3 was never notified.
So, therefore, this becomes academic so far as the assessee is concerned.
Correct.
Though the deletion, omission of the rule was with retrospective effect on the relevant date when you filed your GSTR 9.
Yes.
3 was not notified.
3 was not notified.
So, therefore, you say that your only opportunity to rectify is in the final return.
Final return, yes.
So, GSTR 9.
Correct, my lord.
That's your case.
That is my case, my lord. That is my case.
Now, what he says is, you have not done so in 3B.
Correct.
Therefore, 9 we will not accept. So, your argument should be, when 3 is not notified, I had no other opportunity except to rectify the mistake in 9.
Correct, my lord. That is my only argument. That is my argument.
But you argued something else before the adjudicating authority, I think. He went on a different...
No, my lord, there they refer to the press release, my lord. Basically, they refer to the press release, my lord, which is on page 113. But kindly refer to that press release also, my lord. Page 113.
But there is, all right, assuming that you are entitled to, like GSTR 9 cannot be ignored. At that relevant time, GSTR 9 could not have been ignored.
Correct.
He says that there is no document to support your claim that you voluntarily paid 62 lakhs, 6,20,322.
That I can satisfy your lordship for that purpose, my lord. I have enclosed that 6 lakh challan also, my lord. Probably there was some miscommunication, or my lord, I cannot. But my lord, I have enclosed that challan, my lord, in my petition. But that challan is there, my lord.
But Mr. Siddiqui, if he had no opportunity to file a final return under 3 GSTR 3.
My lord, if your lordship may kindly take the GST book. My lord, in this book, my lord, I believe after the rules there are forms. After the act there are rules and then there are forms. The lordship got those because that is a different publication. আমাদের কপিটা দেন না হ্যাঁ আর ওটা বার কর ওটা Now this is GSTR 3.
Page 4.
It was always there. If your lordship kindly sees the at the top of that page, it has been omitted.
1 second. Just seeing whether the forms are any indexes.
After the rules, there will be the forms. My lord. I'm giving the second book also.
No. It's here. It's here. 349. Oh, this book says omitted.
Omitted, and that too in 2022. Lordship kindly sees. No,
Yes, 28 September 22.
22. So it was very well there in 2017-18 when he says during that relevant period. And GSTR 3B, my learned friend, my lord, when I entered this courtroom, he said that it was never notified. It was notified on the day, and we have taken that stand in our affidavit in opposition on the day when the rule had come into force.
No, 3B was notified. I've never said.
I heard
3B is notified.
Notified.
3 is not.
3 is not notified. It was notified and it has been omitted in 2022.
No, when it was notified?
It was
never there on the portal. They were there on the portal.
Because
Otherwise, my lord, what
notifications, 2 notifications which say page
195 and 196.
The time limit for furnishing details or returns as the case may be under subsection 2 of section 38 and subsection 1 of 39 for the months of July 17 to June 19 shall be subsequently notified in the absolute. Then that once again from July 19 to September 19. So at least up to September 19 it was not notified.
No, but after that also, my lord, if your lordship sees page 199, whereby this rule has been amended. 199, my lord. It is a notification dated 9th October 2019.
Yes.
And it says, my lord, kindly refer to proviso of sub-rule 4. That serial 4, my lord. The sub-rule 5 which has been amended. Provided that where a return in form GSTR 3B is required to be furnished by a person referred to in sub-rule 1, then such person shall not be required to furnish the return in form 3.
Because
they deleted it. But even though effectively the form itself, form was deleted later on in 2022, but for all practical purpose by this amendment in 9th October 2019, they said once you have filed GSTR 3B, no need to file 3. Then where is the question of
GSTR 3B is no more required to file GSTR 3. My lord, that is one case in the hand. What he has done in this particular case, if your lordship kindly takes my affidavit in opposition, it's a very thin affidavit in opposition.
But can he be rendered remediless, sir, because of operation of law?
Then, my lord, GST council has to be brought in. And with regard to that amount, your lordship was saying, my lord, he has not implicated the railways as a party in this proceeding.
No, that he will establish. See that he voluntarily paid about 6 lakhs and odd, along with the GSTR 9. He has to establish that payment because the officer says there is no reflection in the portal.
No reflection in the portal. And for that, my lord, my lord, subject to correction.
Even in those 2 decisions which he has referred. Otherwise, GSTR 9 will become meaningless. No, you please see Rule 39(1).
Section 39.
I'm sorry, Section 39. Subsection 9.
Subsection 9, correct.
where any registered person after furnishing of the return under subsection 1 is 3A. Correct?
Punishing of returns.
Or subsection 3 or subsection 4 or subsection 5 discovers any omission or incorrect particulars therein other than as a result of scrutiny, audit, inspection, so and so, he shall rectify such omission or incorrect particulars, such form and manner as may be prescribed, subject to payment of interest. Now, this rectification in terms of subsection 9 has to be done by.
It was supposed to be done by through GSTR 3, which was never notified. And 3B, they never amended the portal to allow me to.
3B is the provision which deals with GSTR 9.
Well, that section is, but I'll just refer to that annual returns section. The annual return is to be furnished according to section 44, my lord.
So, section 44 read with rule 80.
Rule 80.
See, it's in the 44 also says annual return. Every registered person so and so shall furnish an annual return which may include a self-certified reconciliation statement reconciling the value of supplies declared in the return furnished for the financial year. This return should be either 1 or 2 or 3B. With the audited annual financial statement for every financial year electronically within such time, such form as may be known. The third proviso provides that council may extend the period even after 3 years. Now you come to rule 80. Every registered person other than those referred to in proviso to 44.
Shall furnish an annual return. Financial year as specified under section 44. Electronically inform GSTN on or before the 31st day of this year. Provided that a person paying tax under section 10 shall furnish the substance and GSTN ID.
But there is one problem, whether you can claim input tax credit based on a GSTR 9 return.
But the question is,
But there is some indication.
Yes.
In that you take the form GSTR 9.
Correct.
Take the form. You skip all the tabular column. You come to serial number 18.
Serial number 18.
18 HSN wide summary inward supply.
Correct.
Correct. Verification.
Yes.
Then instructions. You please come to instruction 2, please read, and instruction 4. It is mandated to file all form GSTR 1, 3B for the financial year. Return is being filed before filing this return. And for financial year 17-18, the details for the period July 17 to March 18 are to be provided in this return.
But that is introduced from, my lord, this is notified by notification number 79.
November 2019.
Okay.
14 November.
Then you come to
October 2020.
All right. And now we come to serial number, instruction number 4. Part 2 consists of the details of outward supply and advances received during financial year. It may be noted that all supplies for payment has been received 3B from July to March 2018, 17 to 20, shall be declared in this part for financial year 17. It may be noted that additional liability for 17-18 or financial 18-19, then insertion is there, not declared in GSTR 1 and form GSTR 3B may be declared in this return. However, taxpayers cannot claim input tax credit through this return.
Serial number 9, my lord, your lordship sees words unclaimed during 17-18 omitted by notification 56 2019 with effect from 14/11/2019.
Correct. That word was unclaimed. However, taxpayer cannot claim input tax credit. So whether it is claimed or unclaimed, it has become irrelevant. Probably we can ask him to consider your GSTR 9, but the question of whether you can avail credit in terms of GSTR 9 is doubtful.
No, my submission would be that
to that extent we can send it back.
No, my lord, kindly consider my other
We will
submission.
direct him to consider GSTR 9 in accordance with law. Provided you establish that you voluntarily paid that 6 lakhs and odd in the through valid challan, etc. So let him come forward with this. This point was not considered by. If he is satisfied with your 9, 3 not notified, no opportunity for you. Only opportunity is the annual return, where you can also make what is it? Additional liability. It can be declared in this return.
No, my lord,
because once section 44 speaks about reconciliation, that itself means rectification.
Correct. My lord, kindly consider section 39 subsection 9, whether it can be rendered obtuse. Section 39 subsection 9, my lord.
Correct. That is why the only window open to you is in terms of section 44, read with rule 80.
No, my lord, why I have
GSTR
challenged
9.
No, my lord, why I have, my lord, kindly consider my submission, my lord. Why I have challenged the retrospectivity of rule 61 coupled with challenge.
That the assessee is not going to get a relief, sir.
No, my lord, why I am saying so, my lord? Why I am saying so? My lord, as per section 39 subsection 9, I was entitled to rectify my errors till the due date of filing of the annual return. Now, my lord, the only avenue for me to correct those errors, my lord, the only avenue was GSTR 3.
That is not notified.
That is not notified. So it
That
is
what we are saying. No?
So it is legitimate on my part, my lord, on the principle of legitimate expectation, my lord.
Input tax is a concession, sir. Where is the
No,
question?
no, my lord, what I'm submitting is that.
No. That all, Mr. Sharaf, we will not accept that argument. See, this presumption or this is wrong.
No, my lord, with respect to retrospectivity, my lord, I wish to refer to one judgment of the Honorable Supreme Court, my lord, Jayam and Company. Well, kindly allow me to refer to one judgment only. Jayam and Company, my lord, which is part of my compilation, page 36 onwards. Page 36. Jayam and Company, my lord.
Yes.
Kindly refer to my lord, paragraph 16, my lord. Paragraph 16. Though the later contention was rejected, the first contention noted above, touching upon the retrospectivity of the amendment, was accepted while allowing with the deal in the following manner. Paragraph 18, my lord. Paragraph 18.
See, in that case, we upheld the retrospective amendment.
No, but kindly refer to paragraph 18. For what?
Paragraph 18 only, I'm saying.
Yes.
But then the Supreme Court set aside that portion of the order on the ground.
Retrospectively, they struck down.
Yes, that is, this amendment is to the detriment of the dealer.
Correct.
Therefore, retrospectivity is all other reasonings were confirmed.
Everything was upheld. So this is the detriment to me, my lord, because my lord, my opportunity to rectify.
We will set aside this adjudication order, send it back, and with the reasoning that on the date when he was supposed to file the annual return, Form 3 was not notified. Therefore, the dealer cannot be left remediless. So he has filed his annual return in Form GSTR 9, which is in terms of 44 read with Rule 80. The assessing officer will consider that form and proceed to take provided the assessee establishes that he voluntarily paid this money.
Grateful.
In spite of all these things.
Yes, my lord. Yes, my lord. That much will suffice.
Still, he can say that 9 is not a facilitation process for the purpose of claiming and tax. He may raise that. We let him decide.
Yes, my lord. Let him decide.
My lord, subject to correction, my lord, I do not find anywhere, my lord, subject to, my lord. It was Form 3 was rectified, it was omitted in 2022. But nowhere it has been stated that Form 3 was not notified in the year 2017.
No, this notification is there.
But this notification, your lordship kindly says, what is the wording of this notification which is annexed to the petition?
The time limit for furnishing the details or returns as the case may be under subsection
Lordship
2.
is referring to page
196.
Page 195.
Or subsection 1 of 39 for the months of July 19 to submit shall be subsequently notified. You please take 39(1).
Be registered person.
As may be prescribed.
Now, the prescription at that point of time was in Rule 61, my lord. Rule 61 at that point of time as it existed, page 203, my lord. Rule 61, sub-rule 1, my lord. It says that the return under section 39, subsection 1, in Form GSTR 3.
Where?
But every registered person other than a person referred to in so and so.
Sorry.
I am skipping all that. Shall furnish a return specified under subsection 1 of section 39 in Form GSTR 3.
You are reading for the
section Rule 61. I am reading. It is in page 203, my lord. Page 203. But that book, my lord, is amended rule. That is why, my lord,
substituted in
203, my lord. Page 203 of my petition.
Yes, Form GSTR 3.
3. And my lord, I have referred to that, my lord, the 18th GST Council meeting,
Shall furnish a written
which
form
said that
GSTR 3 does not indicate that form GSTR 3 was not existing.
No, that is why it says the time limit for furnishing the details or returns as the case may be under 39(1) for so and so shall be subsequently notified.
my lord, at that point of time, GSTR 3B was a written under Rule 61, Sub-Rule 5, not 1.
Correct.
That was a written under Rule 61, Sub-Rule 5, my lord.
Sub-Rule 5 deals with GSTR 3B.
तो अभी 205 203 में आप जाइए, पेज 203, उस समय जो एग्जिस्ट कर
हाँ, I have it here also in the book.
नहीं ये चेंज हो गया है,
अरे, this is the portion.
ये वो वाला
Every registered person.
नहीं इसमें
Sub-Rule 5 deals with 3B and Sub-Rule 1 deals with 3.
GSTR 3.
So the time limit for furnishing the return in GSTR 3 was not notified or stood extended.
Yes.
Thus, to mean that it never came into force.
Never came into force. And it was omitted, my lord, as your lordship can see by amendment in
2022.
Rule 6. It was made a dead letter by this 4919 notification, page 199.
See, because 39(1) says every registered person other than so and so, or every calendar part thereof, furnish a return electronically of inward and outward source of services, such as such form and manner, which such time within such time as may be prescribed.
Yes.
The time was not prescribed. As
Never
a result
prescribed.
of which, though Form 3 was there,
it was there.
The portal will not accept it.
No, it was never activated, and it is never there in the portal. It remained in the books in the form of the, my lord, the format.
All right, let us see what. Please come. This intra-court appeal by the writ petitioner is directed against the order passed by the learned single bench in WPA 22096 of 2023, dated 26/9/2023. The appellant filed the writ petition praying for
Prayer is on page 102
Yes.
and 103.
an order of, to issue, praying for issuance of writ of certiorari to quash the order passed by the respondent number 2, dated 5/6/2023, which is an order of adjudication. uh, 5/6/2023, by which a summary order under section 73 within bracket 9 of the CGST Act 2017/WBGST Act 2017 was passed, specifying the amount of tax, interest and penalty payable by the appellant. The appellant also prayed for issuance of a writ of mandamus to declare to hold that the retrospective amendment of Rule 61 of the WBGST Rules 2017 and the omission of Rule 61 within bracket 6 of the said rules as unconstitutional. The learned single bench, noting that the appellant has challenged the constitutional validity of the retrospective amendment of the said rules, directed exchange of affidavits. So far as the merits of the order passed by the adjudicating authority, the appellant was granted liberty to file a statutory appeal. Agreed by such order, the appellant has preferred the present appeal. Mr. Vinay Sharaf, learned advocate appearing for the appellant, on instruction would submit that the appellant's endeavor is to establish that the order passed by the adjudicating authority, namely respondent number 2, dated 5/6/2023 is erroneous. And to support, and one of the contentions on which the appellant sought to demonstrate that said order was erroneous is by contending that that Rule 61 of the rules could not have been amended retrospectively, and Rule 61 within bracket 6 of the rules could not have been omitted. However, today before us, the learned advocate appearing for the appellant submitted that the appellant does not press for the prayer with regard to the constitutionality of Rule 61 of the WBGST rules 2017, and the court may test the correctness of the impugned order passed by the, correctness of the adjudication order passed by the respondent number 2 dated 5/6/2023 in this appeal. Pursuant to directions issued earlier, the respondents, the appropriate authority of the respondent have filed their affidavit, which was taken on record. We have elaborately heard the learned Mr. Vinay Kumar Sharaf, learned advocate, appearing for the appellant, assisted by so-and-so, and Mr. T.M. Siddiqui, learned senior advocate, appearing for the state, assisted by so-and-so. Initially, a notice in ASMT-10, numerical 10, was issued on 21/6/2022, pointing out certain discrepancies in the returns filed by the appellant for the financial year 2017-18, and the appellant was directed to pay tax, interest, and any other amount arising from such discrepancy, and inform the same, and inform the same or furnish an explanation for the discrepancy in Form GST ASM 11 by 21/7/2022. In continuation of the said notice, an attachment to the summary was sent to the appellant dated 5/6/2023, which was impugned in the writ petition, giving the details of the discrepancy detected during scrutiny involving short payment of taxes, excess claim of ITC, ITC reversible if availed, ITC payable, etc. The appellant furnished the reply on 20th July 2022 and uploaded the same in the portal. The appellant contended that they are rendering parking collection services primarily to the Indian Railways, and they paid license fee including GST to the Railway Department, but the Railway Department did not file the return in GSTR1 within time. A reconciliation statement was submitted by the appellant regarding the GST liability. As per the reconciliation statement, the appellant claimed ITC to the tune of CGST rupees 1046,903.00 and SGST rupees 1046,903.00 in the GSTR 3 capital B. In the GSTR 2 capital A, the ITC claimed was rupees 3811,987.06 for CGST and rupees 3811,987.06 for SGST. And by way of the reconciliation, the appellant claimed the balance input tax credit of rupees 2765,084.06 for CGST and rupees 2765,084.65 for SGST, which they had not claimed in the GSTR 3B. The appellant had adjusted this input tax credit towards output tax liability for reconciliation, but it was not allowed, which was not allowed by referring to section 16 within bracket 4 of the Act. The adjudicating officer also observed that in the reconciliation statement filed by the appellant, ITC to the tune of rupees 30,15,875.66 has been adjusted with outward tax liability, which is not shown in the GSTR 2A, and therefore it cannot be availed by the appellant as per section 16 within bracket 4 of the Act. With regard to the claim made by the assessee, the appellant, that they have voluntarily paid rupees 620322.00 as per GSTR 9, was not supported by any document, and it is not reflected in the GST BO portal. Therefore, the reconciliation statement was found submitted by the appellant was found to be not acceptable. The appellant referred to a press release
dated 3/7/19, Your Lordship.
Pardon?
3/7/2019, page 130.
Page
113, my Lord.
Referred to a press release dated 3/7/2019. This, according to the adjudicating authority, the press release is not applicable to the appellant. The assessee, appellant also relied upon a circular
183 dated 27/12/20.
Where is that circular, sir? Page number 27/12/20. All right. Referred to a circular number 183 dated 27/12/2023, which deals with discrepancies between the amount of ITC availed by the appellant in his returns in forms GSTR-3 capital B and the amount of ITC available in form GSTR-2 capital A. The adjudicating authority, on considering the said submission, held that the appellant, having not availed ITC in the form of GSTR-3B to discharge his outward liability, which he has declared in his GSTR-9/GSTR-9C. And therefore, the circular number 183 is not applicable. In support of his first, the learned advocate appearing for the appellant submitted that at the relevant time, that is for the financial year 2016-17, 17-18, though the form in GSTR-3, which provided for the annual return, was in the
monthly return.
statute.
GSTR-3 was monthly return.
Final return. No.
Final return.
Provided
For the annual return.
no, for the final monthly return, the time limit for filing the same was never notified, or in other words, the said form never stood activated, and the intending taxpayer could not have filed the form in GSTR-3 at the relevant time.
Wrong, everyone knows. Please don't disturb.
Section, relevant time. In this regard, notification number 12/2019-CT dated 7th March 2019 and notification 28/2019-CT dated 28 June 2019 were referred to. To test the correctness of this submission, we have gone through the statutory provisions. Section 39 deals with furnishing of returns, and such return has to be furnished electronically in such form and manner within such time as may be prescribed. The relevant rule, the rule which was in vogue at the relevant point of time was Rule 61. And under Sub-Rule 1, the return which was required to be filed under Section 39 within bracket 1 was the return in form GSTR 3. As could be seen from the notification 12/19 and 28/2019, the time limit for furnishing details or return under subsection 1 of 39 for the months of July 2017 to June 2019 was to be subsequently notified in the official gazette. Once again, however, this was not notified, and once again by the second notification 28/2019, the details are returned for the months of July 19 to September 2019 was to be subsequently notified in the official gazette, which continued to remain unnotified. In such situation, it has to be seen as to whether the assessee can be left remediless. In our view, if the assessee has complied with the requisite conditions under the provisions of the Act and rules and is lawfully entitled to the input tax credit, the same should not be denied on technicalities. Section 44 of the Act deals with annual returns, which states that every registered person other than an input tax distributor, a person paying tax under Section 51 or Section 52, shall furnish an annual return which may include a self-certified reconciliation statement, reconciling the value of supplies declared in the returns furnished for the financial year with the audited annual financial statement for every financial year electronically within such time and in such form and in such manner as may be prescribed. Prima facie, we are of the view that the word reconciliation used in the statute could lead to the meaning that there can be a rectification of any error which might have occurred when the taxpayer files his return in GSTR form 3 capital B. Rule Rule 80 of the 2017 rules, sub-rule 1 of Rule 80, states that every registered person, other than those referred to in second proviso to Section 44, a input service distributor, a person paying tax under Section 51 or 52, etc., shall furnish an annual return for every financial year as specified under Section 44, electronically in form GSTR 9 on or before the 31st day of December following the end of financial year through the common portal, either directly or through a facilitation center notified by the Commissioner. The proviso under sub-rule 1 deals with the person paying tax under section 10 who is required to file annual return in form GSTR-9 capital A.
Earlier, it was
It is same, almost the same, almost the same. Form GSTR 9 is the form prescribed for annual return, which is an elaborate form where the taxpayer is required to furnish all particulars, including the reconciliation statement. It is not in dispute that the appellant has filed form GSTR 9. In such circumstances, can the adjudicating authority totally ignore the said annual return while considering the claim of the assessee for input tax credit? More or less an identical issue was considered by this court in
Page 56 of the compilation.
Ankit Kumar Agarwal, proprietor, Ambika Trading Company versus Assistant Commissioner of State Tax, Taltala Charge and others, MAT number 939 of 2024, dated 21/5/2024. After considering the facts of the said case, the court held that if GSTR 9, which was filed within the time permitted, is not considered, the assessee's rights would be seriously prejudiced. It is no doubt true that in the said decision it was held that the decision should not be treated as a precedent. Nonetheless, the court considered the effect of GSTR 9, which being an annual return, which could be filed within the extended period of limitation on account of various notifications issued by the government. In Sri Shanmuga Hardware Electricals versus State Tax Officer, 2024 159 taxman.com 756 within bracket Madras, the Honorable Single Bench opined that took into consideration the submission of the assessee that he is eligible for ITC by referring to the GSTR 2A and GSTR 9 returns. And therefore, the assessing officer was directed to examine those returns regardless the fact that the claim did not reflect in the GSTR 3B. In our view, the adjudicating authority ought to have considered the effect of the GSTR 9 and the particulars furnished therein, rather than to say that what was claimed in the annual return was not reflected in the return filed under GSTR 3B. This would be the appropriate manner in which the case had to be dealt with, since otherwise, the purpose of filing an annual return in terms of section 44 within bracket 1 of the Act, read with rule 80, would become redundant. However, full stop. Therefore, we are convinced that the matter has to be re-adjudicated afresh after considering the GSTR 9 return, the annual return filed by the assessee appellant in form GSTR 9. However, on facts, it is for the appellant assessee to establish that they voluntarily paid rupees 620,322.00 at the time of filing the GSTR 9. Since the adjudicating authority has recorded that no document was furnished to support such claim, and it is not reflected in the GST BO portal. The learned advocate for the appellant submitted that they have got the necessary voucher, acknowledgement for payment, which they will produce before the adjudicating authority. For the above reasons, the appeal is allowed. The order impugned in the writ petition, namely the order passed by the adjudicating authority dated 6/5/2023, 5/6/23, sorry, 5/6/2023 is set aside. Consequently, the writ petition is allowed, and the matter stands remanded to the adjudicating authority, namely the Assistant Commissioner of Revenue, to take into consideration the appellant's GSTR 9 return, examine all aspects, and take a fresh decision on merits and in accordance with them.
That circular 183 is dated 27/12/22. Perhaps your lordship dictated 23, my lord.
Which one? Circular.
Circular 183. It is dated 27/12/2022. Perhaps, my lord, as I heard, my lord, it
will not
27/12.
In the light of the matter, both the appeal as well as the writ petition stands disposed of, stands allowed to the extent indicated, and they are disposed of.
Grateful, lords.
I think, my lord, this will be a somewhat academic, my lord. Your lordship has already disposed of the writ petition. But GSTR 3 was never notified, and that defect was cured by section 60, rule 61 sub rule 5.
Right, correct.
If your lordship kindly read rule 61 sub rule 5 as it existed on that particular date, 2019, where the time limit for furnishing details in form GSTR 1 under section 37 or in form GSTR 2 under section 38 has been extended, the return specified in subsection 1 of section 39 shall, in such manner and subject to such conditions as the commissioner may by notification specify, be furnished in form GSTR 3B, which he has done. He has furnished electronically through the common portal, either directly or through a facilitation center notified by the commissioner. Then, my lord, provided that where a return in form GSTR 3B is required to be furnished by a person referred to in sub rule 1, then such person shall not be required to furnish the return for GSTR 3. So that defect was cured.
Correct. Sorry.
That defect was cured. That GSTR 3 was not there. So through GSTR 3B, one can cure that defect. Now, my lord, GSTR 3B, the form says, the form in GSTR 3B, and he's not supposed to file return. Proviso was there. He's not supposed to file return in form GSTR 3. And he has done so. He has filed the return. Now, my lord, what he has done, he sees the defect. He does not cure the defect. My lord, now GSTR 3 is an annual monthly return, which is filed month after month. 9 is an annual return. He does not cure the defect in a subsequent month, neither in the next month. After 12 months, he comes up and says that I have committed this defect. Lordship may kindly appreciate. And GSTR 3B provides other details. ITC reclaimed, which was reversed under table 4B2 in earlier tax period. And what he has done, he has written about ITC in hand in his return. There is no such concept as ITC in hand. That is what his reply was, which was taken into consideration by the adjudicating authority. The Lordship kindly comes to the adjudication. Well, I should not have allowed there because but reconciliation of GST liabilities, if a Lordship kindly sees.
But it says shall not be required to furnish in form GSTR 3. So its option is available.
My lord,
Option is available.
that
I
amendment
did not
came,
disturb.
one second, sir.
One second.
The amendment came in 2019, my lord. This proviso was inserted in 2019 when Rule 61, Sub-Rule 5 was retrospectively amended. It was not there ab initio.
No, it was there since 2017. What I see, the footnote continued from previous page.
Retrospectively amended.
It was there. And this return, when it was
Page
filed,
199, if your lordship refers to
Lordship
the
kindly
amended
sees
rule.
the reconciliation statement filed by him, my adjudication order, my lord, at page 187, I would not have disturbed your lordship. What he says, input as per GSTR 2A, he quotes an amount, less ITC used in 3B, he quotes an amount, then he writes ITC in hand. There is no such concept as ITC in hand.
No, that language is not proper.
Language is
What he
not
says
proper.
is that he has earned that credit, which he can adjust towards
No,
his
my lord,
output
today,
tax liability.
my difficulty, my lord, as an adjudicating authority, my lord, this entire GST thing, my lord, is also electronically oriented. My lord, I cannot, my lord, allow him, my lord, under GSTR 9 when he says that I want to rectify. And now, my lord, if your lordship had rightly pointed out, under GST 9, he cannot claim ITC. Cannot claim ITC. He has to approach the GST council then.
At least his return will get revised. So it may be beneficial for him in the next year or the year.
My lord, he could have very well revised his return, my lord, in the next GSTR 3B return, which is filed in the next month.
He missed it out.
But he did not do that. For 12 months, he did not do that. And when he files the annual return, he is doing that.
For that financial year, my lord, for that financial year, I have to discharge my liability for 17-18, my lord. For 17-18, unless I have the input tax credit, my lord, I cannot discharge my output tax liability. And that facility to revise the return for any month of 17-18. Suppose the facility for March 18 return is also there, that I can at least revise my March 18 return and rectify everything. So I would have claimed the return in at least March 18 return, and then, my lord, I would have offsetted my liability against my input. So I had the last opportunity for revising my March 18 return. Had they notified GSTR 3, I would have done all this exercise through GSTR 3. But there was, my lord, no facility in the portal. Even today, my lord, there is no facility.
No, today it will not be there because the rule has been amended.
Right. Now,
it's not,
my
may
lord,
not be
the
required.
error in rectification, my lord, it can be, my lord, now also, I can rectify, suppose March I did not claim the credit. I take
in your annual return.
Yes.
Will not your claim for ITC be time barred?
No, my lord, that aspect has been considered, my lord. Section 16(5) has been amended, my lord. Retrospectively, my lord, this benefit has come, my lord.
Subsection 3.
Section 16(5), my lord.
I'll just Section 37, subsection 3. Any registered person who has furnished the details under subsection 1 for any tax period shall, upon discovery of any error or omission therein, rectify such error or omission in such manner as may be prescribed, and shall pay the tax and interest, if any, in case there is a short payment of tax on account of this, provided that no rectification of error or omission in respect of the details furnished under subsection 1 shall be allowed after the 30th day of November following the end of financial year to which the such details pertain of furnishing of the relevant annual return, whichever is earlier. Provided further that the rectification or of error or omission in respect of the details furnished under subsection 1 shall be allowed after furnishing of the return under section 39 for the month of September 2018 till the due date for furnishing the details under subsection 1 for the month of March 2019 or for the quarter January 2019 to March 2019. Quarterly period, not the annual return. Because GSTR 3B is either monthly return or the quarterly return.
Well, kindly refer to, I've submitted, my lord, one Finance Act 2014 amendment, my lord. Kindly refer to section 118.
Section 118.
This is amendment of section 16.
I have it.
Oh, in any return.
118 of Finance Act. It says that notwithstanding anything contained in subsection 4, in respect of an invoice or debit note for supply of goods or services or both pertaining to financial year 17-18, 18-19, 19-20, 20-21, the registered person shall be entitled to take input tax credit in any return under section 39, which is filed up to 30th day of November 2021. So this is a, my lord, facility which is given to, because, my lord, there were several disputes with respect to this time limit of taking credit. Your lordship also dismissed one petition where it was time barred. Then, my lord, the finance ministry considered that the first 4 years, there was some genuine difficulty on part of the taxpayer. They could not file the return in time due to COVID, this or that. So for 4 years, they have given an amnesty that if you have filed the return, you have claimed the credit by November 21 in a return to be filed under section 39, then that is condoned. Now, my difficulty, my lord, is that under section 39, I have already filed my return. I could not rectify it. When I filed my GSTR 9, I was under the hope that GSTR 3 will be notified and I will rectify my error, which never came into, my lord, the picture. So, my lord, is it not legitimate on my part to expect that, my lord, somebody has omitted to take the credit at all, or he is taking the credit up to November 21, he will get the credit. But I have, my lord, rectified the errors through GSTR 9 because I was hoping that GSTR 3 will be notified. And
Here, this amendment doesn't deal with section 44.
Amendment does not deal with 44. Amendment says that you have delayed taking of the credit, then that will be condoned. In my case, my lord, but I cannot take the credit twice over.
GSTR 3 will be notified. Though GSTR 3B provides, the mechanism is provided for rectification of error. But he hopes that if GSTR 3 is
he can't do it in that month.
Well, he could have done in subsequent month.
My lord, I could have taken the credit later on. My lord, my learned friend is correct. I could have taken the credit up to 21.
I don't think so. You'll get that is operation success.
Lordship may kindly, my lord, if the lordship has remanded back, lordship may kindly just observe, my lord, lordship has not, my lord, it's left for the authority to consider the relevant.
Yes, obviously.
Relevant positions of.
We make it clear that that the direction issued should to the adjudicating authority should not be misconstrued as a direction direction issued considering the merits of the matter, but only on the ground that the taxpayer should not be in a disadvantage having not been able to file a return in GSTR 3 on account of the fact it was not notified, and therefore for the relevant year, financial year, the adjudicating authority shall consider the return file, annual return file in GSTR.
Great.
Grateful, extremely grateful.
Navini, sir. Next. Serial number 28.
Yes, sir.
Yes.
This was regarding the Tran 1 issue, the transitional credit issue, lordships. Department since 2018 had issued notices for verification of Tran 1, and I was participating in all the proceedings Around 7-8 communications were exchanged, and there was no observation meets. Suddenly in 2023, they issued me a pre-show cause notice. I replied to it. In the show cause that they issued under 73, they copied the entire reply and stated that this is to be, this has been dealt with. So we came before your lordships on the ground that this issue, under the disguise of Tran 1, they are trying to disallow me the Senvet credit of service tax. So lordship, Tran 1, section 140, subsection 1, stated whatever is your closing balance of Senvet credit, you will take that in the GST Tran 1. So last return which I filed for my service tax regime was on 30th June 2017, which was my ST3 return, lordships. In the ST3 return, if the closing balance is 100 rupees, I can take that under CGST head as 100 rupees. That is what section 140, section 1 stated, lordships. Now, department during the course of scrutiny stated that in the March 2016 service tax return, March 16, they went back 1.5 years back. In the disguise of Tran 1 provisions, they stated that there was a difference in the opening balance in the April 16 return, what as per se what you are disclosing in March 16 closing. They stated this, कि suddenly March 16 closing was 100, April 16 opening should be 100. You have taken 200. So that credit now under Tran 1 verification, they say to that extent your June 17 credit is inflated.
And you challenge the adjudication order.
I challenge the show cause notice, lordship, because since 2018 I was responding. Your lordship noted that in the first order, 2018 I have been responding. No communication, no revert, and suddenly they issue me a show cause without dealing any of my aspects.
We sent it back, no?
No, lordships. Your lordship stated that because since 2018 I have been participating, and without any discussion they have been issuing new notices again and again. For that matter, your lordship admitted it. Your lordship, the order is there, lordship. The order dated.
We admitted the appeal.
We admitted the appeal.
We have filed the affidavit in opposition.
And we have filed a reply
Will be taken on record. But only one thing I will very humbly submit, my lord, this is a show cause stage. Whatever my learned friend is submitting, these are all matters of fact. These are all factual matters.
We gave some reasons, no, for admitting the appeal. Where is that order?
Lordship, 15 December 2023, the first order. May I give one copy, lordship?
From 2018 to 2023, he has been all right. The order of interim stay granted by order dated 15/12/2023 shall continue till the disposal of the appeal. The appellant, the respondents have filed their respondents 1, 2, and 3 have filed their affidavit in opposition, and a reply has been filed by the appellant. Pleadings are complete. The learned advocates for the parties submit that all documents are available in the stay petition and pray for dispensing with the filing of informal paper book. Accordingly, filing of informal paper book is dispensed with, and the stay petition shall be continued to be retained in file. List the matter for hearing. 2026.
Lordship, so kindly, lordship, your lordship dealt with, lordship, this is covered by Jharkhand High Court. That was placed before your lordships.
Jharkhand High Court, they have filed appeal in Supreme Court.
No, lordship, I have an RTI copy of that. Usha Martin, RTI copy says they have accepted that judgment. That RTI copy.
West Bengal has not accepted.
Yeah. No, Lord, not covered.
Persuasive.
Persuasive. Lordship, in February, lordship.
No. Not February.
Lordship, then gives the lordship, gives sir.
All right, Matlab, yes, next.
Great.
Petition number 29.
Appear for the appellant. On the last occasion, your lordship was pleased to admit the appeal and club this matter with Girdhalal Dalmia, Lord, which your lordship has already admitted. But what I was humbly praying for the timing, if your lordship kindly sees paragraph 4 of your lordship's order. My lord, I was for the timing, I was very humbly submitting, Lord. For the timing, let the matter go out of the list
with liberty to mention, my lord.
All right. Let this appeal be tagged along with.
Already has been tagged.
Already tagged. The learned advocate for the appellant submitted that the appeals have to be heard finally. Place up for adjournment. Let the matters go out of the list with liberty to mention for information. Thank you. Next.
I am extremely grateful.
Serial number 30.
My lord, may I please your lordship? My lord, if your lordship remembers, I mean, after quite a period of time, the matter. My lord, my point was that regarding rectification of my return, the return was of the first quarter or first year rather of GST, that is 1718. And there was no, I had exhibited before your lordship that unlike in service tax, there is no rectification, at least that point of time, provision for rectification of return. And I have cited, in fact, I have filed the affidavit, if your lordship sees, where I have cited the Honorable High Court at Madras and Bombay have affirmed this view.
Have you filed any
No, they have
reply
not.
to the supplementary affidavit?
So,
Because
they can.
according to the SSC, if you see our order dated
Activity now.
6th of August, writ petition has been filed challenging the final adjudication order by which credit was denied to the appellant on the ground appellant could not produce any document or proof of payment evidencing the payment of such amount to the government exchequer, either by debiting the electronic cash ledger or electronic credit ledger. Submits that the information was furnished to the adjudicator. There are documents in possession. Liberty is granted to file affidavit. They have filed affidavit.
Yes, my lord. And I have served them also.
Yes. Where is
But
your reply?
they have not filed any.
They have not filed it. Lordship, kindly give us direction, we'll file reply to this.
All right. In terms of the directions issued,
Kindly keep the point of maintainability open because we are challenging.
that is always there, sir. In terms of the directions issued earlier, the appellant has filed supplementary affidavit along with enclosures. The learned advocate appearing for the state requests time to file their reply. Let such reply be filed within 3 weeks from date, and copy be served on the learned advocate for the appellant.
You are keeping the matter?
3 weeks.
After 3 weeks?
Yes.
I am grateful, your lordship.
Next.
Serial number 31.
31.
My lord, Mr. Obro Mujumdar is appearing in this matter. He is appearing before the Honorable Supreme Court, man.
We saw him, no? Senior. All right.
We are for the respondents.
Any urgency it can come?
As your lordship pleases.
We do it in March. Next.
Grateful, my lord.
Serial number 32.
I appear for the appellant. Your lordship, I appear for the appellant. I am led by Mr. Pratyush Jhunjhunwala. He is not well. I seek for 1 week accommodation.
All right, 1 week at the request of counsel for the appellant. 2 weeks you take. No, give a date in 2nd week of February.
This is a matter, my lord, wherein, my lord, your lordship had observed on the last occasion that the learned single judge, my lord, did not address the legal point. Ultimately, my lord, that legal point has been decided by that time, my lord, that was not decided by the Supreme Court. Now it is saying in favor of the revenue. So let Mr. Jhunjhunwala come.
March, like this March.
Your lordship, only 1 week accommodation.
Pardon?
1 week accommodation. I seek for.
You are asking 1 week. I am giving 1 more week. Lordship is giving 1 more week. So 3 weeks you get.
Grateful, your lordship.
Serial number 33.
Assigned group 4.
Yes, this is a writ petition, my lord. The challenging the point, my lord, my application before the tribunal was dismissed without serving any hearing notice. There is a specific provision. If the application is admitted before putting the matter for hearing, the registrar will serve the notice. No notice has been served, and in my absence, my matter was dismissed.
And what happened to your writ petition?
Writ petition has been primarily filed before.
Against the tribunal's order.
Tribunal's order has been assigned.
Where is the tribunal's order?
But page 12 and 13 are the relevant pages, my lordship kindly see. Oh, this is the writ petition which has come up before your lordship. So there is no
single
reason, because he had filed a writ petition before the honorable sitting
Subsequently,
bench.
I have filed the second copy. Second judge's copy I have filed. I have given.
But you are threatening the tribunal.
No, my lord, the language is very clear. Kindly, I am reading out once again, my lord, what I have written. It has misinterpreted. I am reading out, my lord.
Have you filed in the department?
No, এখানে দিয়ে গেছি।
No, in this appeal, at least in this writ petition, have you tendered any apology like that?
No.
Saying that whatever I sent was misconstrued. Where is your email?
Lord, it is my email, page number 11.
Non-compliance of court. Sir,
Lord, only most interesting, after receiving this bill, immediately on the next very the matter has been listed. Prior to that, on several occasions, the matter was mentioned before the register, that has not been listed. That magically, upon receiving this mail, they have taken the note very seriously, but matter has been listed the next very day.
but at least now in your submissions, are you tendering?
What happened actually after
No, after in your submissions, are you tendering apology for having hurt the sentiments of the tribunal?
Lord,
You can record that.
actually, what happened actually, it was not meant for the benches. It is for the officer in charge who is responsible for listing the matter. I am indicated that person only.
Registrar is also a judicial officer, my lord. Yes.
Lord, even that will not be considered.
This writ petition has been filed challenging an order passed by the learned West Bengal Taxation Tribunal, by which dated 6/12.
That was not the point at all in any point.
By which the appeal, petition, application was dismissed for non-prosecution. Sir, 7/12, sir, 7/12 was dismissed. In the order date passed by the tribunal on the earlier date, that is 6/12/2023, the tribunal has observed that the learned advocate had sent an email to the registrar containing a veiled threat that non-appearance of the matter in the cause list amounts to contempt of court, irrespective of the position of the contemptor, and there was a request to list. It is no doubt true that the manner in which the email was sent by the counsel to the learned registrar of the tribunal is not in good taste. The learned advocate appearing for the writ petitioner submitted that that there was no intention to disrespect the learned tribunal or the learned registrar of the tribunal, and the anxiety of the client was to get the matter listed on an early date. Therefore, it is submitted by the learned advocate that on behalf of that unconditional apology is being tendered, which may be considered by this court, and the learned tribunal may decide the matter on merits. We have heard the submissions of the learned. We have heard the learned senior advocate appearing for the state on the above submissions. While not appreciating or approving the tenor and manner in which the learned advocate addressed the learned registrar of the taxation tribunal, yet bearing in mind the plight of the client who went before the tribunal, we condone the conduct of the learned advocate who had issued the communication, and consequently set aside the order passed by the tribunal and restore the application to the file of the learned tribunal to be heard and decided on merits. The apology tendered by the learned advocate is placed on record. Yes. We'll stop with this. 4:15. Sir, there was one clock there. That is the display board. Where, what happened to it? Oh, have to put somewhere. They put on nail immediately. If there is any existing nail, you ask them to search in that you have.